Okay, we'll go ahead and start the conversation here today. First of all, welcome and thank you everybody for joining us today for the July meeting of the Governor's Focus Committee on Criminal Justice Reform. My name is Adam Gregg. I'm very honored to serve as Lieutenant Governor of Iowa and as the chair of this committee. As you all know, we were hoping to have this meeting in person, but just decided in light of the circumstances to go ahead and do it by Zoom. We were struggling a little bit to find a venue in Cedar Rapids that was both the right price and large enough for us to be able to socially distance and accommodate everybody who would want to take part in this. So decided that we just go ahead and do this by Zoom, which of course gives us some accessibility opportunities as well, where folks statewide can easily click a button and be a part of the conversation and hear what's going on. Before we get too far here, I do want to acknowledge that the passing of Congressman John Lewis, which we learned about on Saturday morning, such an incredible legacy of fighting for justice and equality. I think it's very fitting that just a few days after his passing, we'd be having a conversation like this, which one could view as a continuing the conversation that he's been such a major part of throughout his entire life. Governor Reynolds has ordered the flags to fly half staff here in the state of Iowa. I think is also a fitting tribute to his life and legacy and a recognition of his work. And so I just wanted to start out by acknowledging his passing and how much we'll certainly miss him and his contributions to our country. Before we go too much further, we do need to conduct the roll call. So I will turn it over to Nate Bristow to conduct the roll call real quick.
Okay, give us 1 second here as we will unmute the committee members. And then I'll start. All right, Lieutenant Governor Gregg. Betty Andrews.
Present.
Director Skinner.
Present.
Helen Miller. Helen might be on by phone. We'll see if I can determine what phone number she's in on. Let's see, Commissioner Baines. Oh. Okay. Director Bradshaw let me know that she wouldn't be able to attend today. Al Perez.
Present.
Bruce Vandersanden.
Present.
John Kufos.
Present. Good morning, Nate.
Morning. Janelle Malone.
Present.
Jennifer Miller.
Present.
Chief Potts, I saw him come in. I don't know if he's also coming through on a phone for the audio. Chief Potts? Okay.
I'm here.
Got it. Right. Sheriff Lane? And Isaiah Knox.
Okay, outstanding. Thank you. Thanks for, again, your patience and grace as we conduct this by Zoom. Nate and I are in the same room, so we have to do a little bit of a balance there when we're both engaging and in terms of who's muted and who's not, so we don't have a bunch of feedback. So thanks for your patience with that. First order of business is to approve the minutes from our last meeting. They were distributed, and I guess I would look and see if there's anybody who's willing to move to approve the minutes from our last meeting.
So moved. Tim Lane.
Thank you, Sheriff Lane. Is there a second?
Darius Potts, second.
Thank you, Chief Potts. Is there any discussion? Seeing none, those in favor of approving the minutes, say aye or indicate with a thumbs up on your screen.
Aye.
Aye.
All opposed, nay. Hearing none, the ayes appear to have it and the minutes stand approved. Again, before we dive into today's agenda, I wanted to take another moment to highlight an op-ed that ran in the Des Moines Register here just last week, highlighting the important work of this year's licensing bill, which of course was a direct recommendation of this task force. And it deals with, one major element of that bill deals with folks who have criminal convictions who are trying to re-enter the workforce. And we'll have Nate send this out to the group if you haven't had a chance to see it. The headline is "New Job Licensing Law in Iowa Will Help Ex-Offenders Find Work." And I'll just share a few excerpts. I'll paraphrase somewhat, but just a couple things that jumped out at me from this op-ed. Today, nearly 1 in 4 Iowans need a license to work, but roughly 1 in 3 Americans have a criminal record of some sort. So that means that licensing boards have become a major gatekeeper to ex-offenders who are seeking a fresh start. And this op-ed comes from a person who's affiliated with a group called the Institute for Justice, which looks very closely at licensing regulations generally across the country, but does specifically take a look at the impact of criminal convictions and the access that ex-offenders have to being able to work. So one of the things that he mentions in this op-ed is that Iowa initially received an F in their report from the Institute for Justice that's called Barred from Working. But with the passage of that bill and the provisions that were included in that, it's House File 2627, Iowa became the 3rd best country in the state. So we went from last in their rankings to number 3, which I think is really outstanding. And then he goes on to highlight some of the elements of that, looking at the link that bill had to the criminal conviction being directly related to the licensure, looking at safeguards in the due process of the licensing application process. And one of the things that he highlights is that how important it is that ex-offenders can petition the board to find out if their criminal history would disqualify them before they start the training or classes for a license, which I'm sure everyone remembers was really a big part of our conversations when we were debating those recommendations last fall. So again, there's something we've talked about. It's great to see a direct recommendation like that be passed into law. It's good to see it getting the recognition that it deserves as well in the media. So we'll get that distributed to the members of the committee, but I just wanted to take a moment to highlight that here today as we start out. Looking at the agenda for today we're going to be hearing from advocates and experts from many different areas of the criminal justice system that we're examining. And just a quick reminder of the process that we're undergoing. During our last meeting, we had guest speakers who talked about, gave us a broad overview of racial profiling legislation that's been considered by the Iowa legislature over the past few years, but has not passed. And we're using this meeting and future meetings to dive deeper into the various elements of that legislation, and also looking at what other states and jurisdictions have done, both across the country and also local jurisdictions here in Iowa. So today, first we'll take a brief little detour because we'll be hearing from one of the leaders of a new law enforcement equity task force, which I think is a really positive development. After that, we will hear from representatives from numerous different localities, including University Heights, Des Moines, and Cedar Rapids, and they're going to be discussing local ordinances that have been implemented or are under consideration in an effort to encourage unbiased policing in their local jurisdictions. And I think that's, again, a key part of our conversation. We're looking at this from a statewide perspective, but of course, local ordinances can impact this conversation as well. Also remember that an element of that proposed profiling legislation that we got a broad overview of last week was a ban on discriminatory pretextual stops. And so today we're going to take a look at what does that mean exactly? There's actually a recent Iowa Supreme Court case on the topic called State versus Brown. And we're going to talk about some of the legal issues that were decided in this case. And I know that Nate sent a link to that, and I hope each of you had the opportunity to read it. It's kind of a long one when you read the majority opinion and the 2 dissents. But what I found in reviewing that case is that it actually, through that case, I think it can help be a launching pad for the policy considerations around that issue. And so I'm looking forward to having that discussion as we go on here today. So with that, why don't we get right to it? Since we last met, there's been a very encouraging development and a new partnership. And it's between the Iowa Police Chiefs Association and the Iowa-Nebraska NAACP. They've teamed up to create a law enforcement equity task force. And it seems to be such a great collaboration, and they're looking at some parallel issues that we're looking at. And so today we invited Kevin Sanders, who's the president of the Iowa City NAACP, to just give us an overview and an update on the work that they're doing. Kevin, I thought maybe we could have just kind of like a 5-minute update on the issues that you're looking at, and we'll leave a little bit of time for questions before we move on in our agenda. So with that, welcome to Kevin Sanders, and we'll turn it over to you.
Thank you, Lieutenant Governor, and I would like to thank everyone for inviting me. The purpose of this special task force is to create a common ground that helps seek change and open more communication that improves relationships between law enforcement and communities of color. This includes building on recent improvements in addressing racial profiling, hiring practices, establishing citizens review boards, and primarily officers living in community state police. The first meeting we had on July 9th, it was a really good meeting, and what we wanted to do was establish an icebreaker, introductions to get a feel of everyone and throughout the region and listen to some of their concerns. We started off with establishing ground rules as far as the communication, what type of information could be shared. That was really helpful. We talked about other considerations, like setting schedules. How often would this task force meet, whether it was monthly or quarterly? At this time, considering it's toward the end of the year, we are going to try to meet monthly. I know that Johnson County will be hosting the next meeting sometime in mid-August. Methods for public input. One of the strategies we discussed was allowing input from the community through surveys, and we would review those surveys and create an agenda based off those surveys. Also, the collaborations, we felt that was very important, community initiatives, and that's working with all of the leaders. Betty Andrews made a good point that it was very important that everyone have a voice at the table in regards to the concerns with law enforcement, and we collectively agreed. And also, one of the other concerns was, this is still up for discussion, but we want to have some of the meetings open to the public. That way we can have an effective dialogue. So we're still in the progress of working on that. Some of the other task force topics for future meetings: accreditation, professional standards, implicit bias trainings. I know in Johnson County, I would like to focus on citizens review boards. Over the past week or so, I met with the North Liberty Police Chief, Coralville Police Chief, and they're very, very interested in pushing this forward as far as an anti-racial profile ordinance with a citizens review board included. So I'm very optimistic about Johnson County and what we're going to do in the future. And I believe the collaboration between the NAACP and law enforcement is setting a precedent. And I believe it all started with the Iowa City branch was reactivated, I believe, in the fall of 2017. What I did differently was I reached out to law enforcement officials, primarily the Iowa City Police Chief, former Iowa City Police Chief Billy Matterly, the University of Iowa Police Chief Scott Beckner, and we talked about collaborations. And through those collaborations, we hosted a hate crime forum to address concerns as far as hate crime flyers that were being distributed through Iowa City. And that proved that through collaborations, we could accomplish a lot. And we went on the next year to host a hate crime training with religious officials. So because of that, the University of Heights police chief reached out to me, and he wanted to know how could his police department assist with collaborations. And from there, we went on to work with them as far as enacting the state's first anti-racial profile ordinance, which was spearheaded by Sylvia Quesada, who's a city council member. She reached out to Betty Andrews, and Betty Andrews provided the guidance, and that's where I took the lead from there to establish the racial profiling ordinance. So at that time, if you have any questions, I'll be glad to answer. Hello?
Sorry, I needed to be unmuted. Sorry about that, Kevin.
Okay.
Thank you for that update. Really encouraging to see that work come together. A couple things should note. Chief Jeremy Logan of the Owine Police Department is Kevin's co-chair. He wasn't able to be a part of this meeting. We did extend an invitation to him as well. So he sends his regrets. And he's also the immediate past chair of the Iowa Police Chiefs Association. I'd also note that it's got some really highly respected members, including Commissioner Steve Baines, who's part of this group as well. And so it's nice to have that connection as well. I'd open up to any questions from members of the committee. If you could just sort of either physically raise your hand or use the hand raising function, and we'll make sure we get you unmuted. Go ahead, Betty.
Sure. Well, I just wanted to take a moment and thank our Iowa City president of the NAACP, Kevin Sanders. He has done a really great job over the last 3+ years, actually, because I know he mentioned the reactivation of the Iowa City unit. This is something that has been going on with the Iowa, Nebraska NAACP. We have been reactivating several of our units that had gone dormant in some of, usually some of the smaller cities, but also in places like Iowa City. So we're grateful to work with Kevin on that. And then also, I know that Kevin has a very strong interest in criminal justice reform, and been acting to that end, beginning with some of the collaborations he mentioned, but then also to note one of the strategies, Lieutenant Governor, you mentioned earlier, that we have had this proposed legislation on anti-racial profiling in the House for some time, for several years. And one of the strategies that the NAACP decided to take on when we'd made some movement in the Iowa House, but not necessarily, of course, what we would like to have seen at that point, which would be law. But the strategy that we took on was to start working with different municipalities on creating anti-racial profiling legislation locally, so that, number one, our representatives could see that there is a very strong interest in that, and also to remind people how many other states and municipalities already have anti-racial profiling legislation, and that Iowa needs to kind of connect with where we are in this century. And so it was an honor when we first received contact from the University Heights City Council, and then me directing Kevin to take the lead in working through that, and then me coming back in and helping negotiate that ordinance. So just very excited about that. And it's a really good ordinance that includes a citizens review board. And I know we'll hear more about that from Chief Kelsey going forward. But also this new collaboration that you're mentioning, and I lost the name, but the Equity Committee, essentially, with the Police Chiefs Association, really is an awesome opportunity for many groups to get together and when I say many groups, many law enforcement agencies and community advocates, community representatives to really have that conversation at the chief's level, but then also bring in that grassroots level and make sure that that gets out to the public. And so, Kevin, I know that this is in its infancy. You just had your first meeting. It's an honor to see you presenting to this group. But I guess I would wonder, what is the spirit been with the police officers, the police chiefs, and sheriffs? I know you've been working with quite a few different officials, as the Lieutenant Governor mentions. What has been the attitude in working with them at this time? Because we know that we're in a time where we're experiencing, with the death of Mr. Floyd and some of the protests and some of those concerns. So tell us a little bit about, and again, understanding it's been in its infancy and there are other people that can speak to that, but just wanted to check in on the attitude that we're seeing in the spirit. Commissioner Baines, you may want to weigh in on that also.
Thank you, Betty. Well, actually, I would like to start back at the meeting we had in June at University Heights with all the police chiefs, the current chief of the Police Chiefs Association, past president. It actually set the tone. Everyone was really excited. There was some concern because the NAACP was involved and we were responsible for coordinating the meeting because of everything that was going on. Some law enforcement officials felt they were going to be scrutinized. However, that wasn't the case. After that meeting, as I said earlier, I had one-on-one meetings with police chiefs, and they said they were very impressed that the NAACP was able to provide a solution as to addressing some of these issues by working with law enforcement. And that energy carried on to our first meeting. A lot of the police chiefs were really excited because they said that Iowa, and they still feel that Iowa law enforcement is at the forefront of change. And it just so happened that it's really about the timing right now, considering everything that's going on, is that everyone understands that in order for us to create change, we have to do it together. So the energy is really great right now. I've been communicating with chiefs from all over the state, and they're very supportive of the special task force and our vision.
I will add that initial fear and concern was more because they just had not worked with the NAACP or as strongly with communities of color, and being able to come to the table was really a game changer for them. So just wanted to add that. Commissioner Baines, did you want to have any commentary?
Sure. I think, can you hear me okay?
Not very well.
Can you folks hear me or no?
Yes.
Kind of quiet, Commissioner.
You're on mute.
Yeah, you're going to have to unmute him, Nate.
Can you folks hear me better now?
Much better.
Yes.
All right. I think it's very optimistic. I think, one of the things that we chatted about quite a bit at the meeting was kind of blending private occasions to talk very frankly with public occasions to make sure we have accountability. And I think that's one of the things that I thought was one of the best aspects of this, is because there is a lot of scrutiny and a lot of politics that are involved in some of this. And I think there was folks that had some concerns about the ability to speak frankly and to acknowledge certain things without it becoming a soundbite somewhere else. And so I do really appreciate kind of the discussions that we had in the group about blending kind of the ability to talk privately and candidly without it becoming sound bites, and so that we can really try to move forward and see everyone's position. So it is. I thought it was a good group. It was a very optimistic group. I was really impressed with the representatives from Sioux City and the NAACP out there, just to see how engaged they are in their community, how engaged they are with their police department up there. It was just a very good example of what that relationship can look like.
And one more thing I wanted to make sure that Kevin mentioned was at that first meeting in Iowa City, there was a memorandum of understanding that was signed. Do you want to share about that, Kevin?
Sure. One good thing about the meeting was all the law enforcement administrators in the county signed a duty to intercede, which basically holds all law enforcement officials in the county accountable if they're not following protocol or use aggressive policing. And this got the attention of George Floyd's first cousin, Paris Stevens, on whom I'm good friends with. She reached out to me and wanted to thank the NAACP and local law enforcement for the way we took action. And actually, after we leave the conversation today, there's an article in the Gazette about the interview that the Gazette interviewed Paris Stevens, myself, Betty Andrews, and other law enforcement officials about the work we did. So that was really interesting.
And we'll get a copy of that article to Nate. But I just want to reemphasize, it was a memorandum on the duty to intercede. So if an officer sees another officer acting up or not following protocol, they have the duty to interfere. So we thought that was a significant memorandum. So thank you. That's all I have. Thank you.
Thank you. Other questions or comments before we move on in our agenda from other task force members? Okay, seeing none, thank you very much, Kevin. Really appreciate you taking the time to join us today, give us an update. I think it's important for this committee to remember that there are other conversations on similar topics going on in parallel, and that's a good thing and a healthy thing. And I think they all come together well, and appreciate your work. And thank you to Kevin and to the Iowa Police Chiefs Association, who are a key part of that as well. Next up in our agenda, we will be moving on to a panel discussion with representatives from different Iowa cities. And again, just like this past conversation on the Law Enforcement Equity Task Force, our conversations aren't happening in a vacuum. And so there are local jurisdictions that have looked at these issues. They've wrestled with these, and they're at various stages of implementation, from being under consideration to having just passed to having been on the books now for some time. And so I thought we could learn a little bit from their perspectives as they've worked through some of these policies. And so with that, I'll just briefly introduce the members of the panel, and then I'll recognize you individually. What we'll do is we'll give each of you, say, 5 minutes to give us an update on where things stand in your city. And then we'll open it up after the entire panel has presented to questions from the committee and further discussion. So members of our panel today are going to be University of Heights Police Chief Troy Kelsey. We've also got Des Moines City Manager Scott Sanders, and Cedar Rapids Mayor Brad Hart, and Cedar Rapids Police Chief Wayne German. So we appreciate everybody taking the time today to be a part of that. And we will start out with probably the city that's farthest along in implementation, and that's University Heights. So I will recognize University Heights Police Chief Troy Kelsey.
Thank you, Lieutenant Governor, and I appreciate you inviting me to be part of this. Touching base very quickly on some things that were already said, I don't think our ordinance exists in a vacuum. If Kevin in particular had not done the work that he had done, and I know Betty came down here also, but I was with the Iowa City Police Department in 2015 when I was promoted to captain, and that's when I met Kevin. He was beginning with the there, and more than our ordinance, or maybe as a result of that, it's that relationship, that rapport, and that trust. It doesn't mean that Kevin doesn't call us out, or the NAACP does not call out law enforcement if something goes wrong. They do. They just don't do it on the steps of the Pentecrest. They come in, we have that trust. He can come in and he can say captain or now chief. what happened here? We're hearing this through social media. You may not even have a formal complaint yet, but we're hearing this. Can you fill me in on the particulars? And we can share information. And I know because of our relationship that I can share information with them, and it isn't going to end up in an article in the Gazette or the Press Citizen unless it be there. It's not going to be, hey, look what Iowa City Police did or look what University Heights did. So it's because of that groundwork that had been laid and because of that trust and rapport that we ended up with in University Heights, our ordinance. As Kevin stated, this was brought forth by a then city council member. I think that the draft she had was with the ACLU or that she had received from the ACLU, but once the council started looking at it, they found that that had originally come from the NAACP. We talked about earlier discriminatory pretextual stops. That is defined in our ordinance. Our ordinance, including the signature page, is six pages long, and it talks about pretextual stops. It talks about discriminatory pretextual stops. It talks about specific suspect description-based notifications. I mean, it goes through, and it doesn't take a long court decision to define each of those, but it does it all, I think, very concisely and in a manner that officers and public can understand. And I think that communication is what's key. It shouldn't be so obscure or so clouded or so legalese that people don't know what it means or how does it apply. It establishes a few things. A citizens advisory board. When I was with Iowa City, we had a citizens police review board that was very broad in scope. Now, if I had cancer, I might go to my family doctor for a reference, a referral, but I wouldn't go to the family doctor for cancer. I'd go to a specialist. The University Heights Citizens Advisory Board that was established is very specific to that, if you will, that cancer of discriminatory practices, racial profiling and police. And the board addresses only complaints or reviews only complaints that are specific to discriminatory practices, discriminatory practices, discriminatory policing, disparate treatment. So it isn't dealing with, it isn't interacting on a daily basis or on a regular basis with the police department. It's only interacting with us when there is something that really rises to the level of needing attention. The Citizens Advisory Board by our ordinance is really not political other than it exists under our city government. There's no city council members that sit on it. There's no elected officials that sit on it. There is a selection committee that was comprised of 2 city councilors and Kevin Sanders, but it's the ordinance specifically says the president of the Iowa City chapter of the NAACP or his designee. We chose to align with the NAACP in part because of their long storied history in dealing with these issues. There are many, many other voices out there, many, many other organizations and individuals. Not everybody needs to sit at that table. It gets too complicated. There's too many different agendas. That's not to say that everybody doesn't have a voice. They do. They can come address the committee. They can come address me. They can certainly go speak to the NAACP. But we chose to deal with, we wanted a small functioning board that could actually meet and accomplish things as opposed to frankly, some university meetings that I've been at where the boards consist of 100 people. There's a lot of talking, but nothing accomplished. Dialogue is great. Meaningful dialogue is great, but it needs to be followed by meaningful action. So our advisory board by ordinance consists of 3 community members, a representative from the NAACP, and an individual that has either current or past law enforcement experience so that they have that perspective. We're a tiny community. Those 2 special positions, the NAACP and the law enforcement position, they may be from our community members, but they don't have to be. We only have about 1,200 people, and I think that it would be difficult. We have 3 of the 5 members represent our specific community. 1 member is the probably longest standing or most recognized member, NAACP, from an advocacy group, and the other gives that law enforcement perspective. And no elected officials, no police officers, no police chief. We want to work closely with the board. We want to give the board as much access as possible and have as much open communication as possible. We want them to be able to be part of the process, not just an inbox for complaints, and then they get a report from the police department or whomever later saying this was investigated and here was our findings. So to that end, and again, this is not all finalized because we've not yet had a complaint, Lieutenant Governor, since the board was established, but I would like to see the board act as actually not just receiving the complaint, but screening the validity of the complaint and giving direction to police about what they want investigated. So somebody complains, I pull all the evidence, whether that's written reports, body cam, in-car camera, jail records. I pull everything and we sit down and we review it together. And perhaps that answers whatever the issue was. Perhaps it very clearly shows in the, for example, the body cam, you know what was alleged to have occurred did occur. Now let's move on to why it occurred and addressing it, not just in this issue, not just in this incident, but how do we address it moving forward through training, oversight, personnel changes, so that it doesn't repeat itself. So we address both. We try to redress what happened that was wrong and try to fix it moving forward so it doesn't repeat. Or maybe the board reviews the video and says, you know what, the complainant alleged that these things happened. There's very clear video that never happened. This does not need to go any further. More likely it's somewhere in between, and the board can say, Chief, here are the questions we would like you to ask when you conduct your investigation and bring those answers back to us. So I want to see them involved as much as possible so they don't become frustrated and they don't wonder what's going on in the police department because they're not privy to that. So to that end, I think that we have established a good framework. We'll see how it plays out moving down the road. But I like the composition of it. And again, I would hope that ability to communicate openly and address issues, let them ask the questions and let police be held accountable. I would hope that, I'm very hopeful that that will work and that it will actually improve on some of the issues that Iowa City Citizens Police Advisory Board struggles with. We also have a data collection piece that was very easy for me to implement in that I work with Iowa City. We do use Dr. Barnum, a professor at St. Ambrose. He's been analyzing Iowa City's data for probably 10 years or more. Davenport, about the same time period. I know that he's done at least a one-year study for Dubuque. Both the Ames Police Department and the Iowa City Police Department started using his services 2 years ago. And we collect data, demographic data on officer-initiated stops, searches, but everything that's officer-initiated with a traffic stop for analysis. And it helps us look in the mirror. It doesn't do any good if I say our department has good policy and good practices if nobody else believes it. So this lets us look in a mirror and that data will be published. We have not yet completed a year cycle of analyzing that data yet. We started earlier this year. I think that's most of it. Is there any questions specific to University Heights? So far, it's been very, very well received. We did not have any problem getting members to volunteer for it. Again, they went through a selection committee. I'll freely admit we don't have the most diverse community in Iowa City, but even given that limited pool, we have youth represented, we have aged represented, we have women, we have men, we have professionals, we have immigrants. We don't have a lot of persons of color in our community to draw from. So that is where, again, the NAACP and their representative can help us deal with our deficiency in that area.
Well, thank you, Chief. Appreciate your presentation there. And I know I've got a few questions. I'm sure our committee members do as well. What we'll do for efficiency's sake, though, is we'll keep going through our panelists and then we'll open it up to questions to the entire panel, because I think some questions may be similar based on other provisions of other local ordinances. So with that, I will now recognize Scott Sanders, who is the city manager for the city of Des Moines. Scott?
Thank you for having me, Lieutenant Governor. I assume technology is working. Hear me okay?
Yes, we can hear you.
Excellent. Well, again, I appreciate you having me in this conversation today. you're going to hear similarities with the City of Des Moines Ordinance to that of University Heights. But I thought I'd first talk a little bit about the process that we went through, because oftentimes the journey is just as important as the outcome. In this case, an opportunity to set up and develop new relationships, specifically with Betty Andrews, and I'll reference her later in my conversation in the NAACP, but other advocacy groups as well. The value of the transparency in having public input. At one point, over 1,000 participants in one of our Zoom meetings. That transparency is very valuable as well. So I'm going to speak first to the process that we went through, and then the actual details of our ordinance, if that's all right. So this ordinance in Des Moines, and the process was all about unbiased policing. So it was larger than just racial profiling, and we included conversations about code enforcement here in Des Moines as well, making sure that wherever there was either a law enforcement or code enforcement, there would be applicable direction to be given. The council directed the staff to draft the actual ordinance quite a while ago, back in 2018, so we've spent quite a bit of time on this. At first, I directed the Civil and Human Rights here in Des Moines to seek and receive public input on elements of what could become a draft ordinance. And so they spent a fair amount of time getting that public input and then reporting back to myself, the police department, and legal staff, and for which we actually drafted the language and got more public input. It was at that time that we also started to talk briefly and communicate with the NAACP and Betty Andrews to get more input. There was a first draft received by council and voted on at a first reading, but the discussions continued, and it does take 3 readings to pass an ordinance. And it was identified that significant changes still needed to occur even after that first draft. And so again, working with Betty and other advocates, community advocates here in Des Moines, significant changes were made to our ordinance between that first and second reading, to the point where legal advised us that we should start over with the first reading. There was a redirection, if you will, on a lot of the language to make sure that it accurately reflected what was in place with the police department policy at the time. There was a policy that the police department enacted in 2018 called Unbiased Policing, and it has a lot of similarities to the ordinance that was eventually passed here in Des Moines. The first reading then reoccurred, if you will, under the new language on June 8th, but there was not an opportunity to have that draft out in the public long enough to get additional public input, and so it was decided to not expedite the second and third reading, but have additional conversations, for which, as you might imagine, additional changes were made and improvements to the ordinance language. And it was brought to the council then on June 22nd for the second reading, and with the recommendation and support from our advocacy groups, we were able to waive the third reading on June 22nd and get our ordinance here in Des Moines passed. So very proud to have that accomplished, but there's an awful lot of work established within that ordinance and other resolutions by the council. We've still got an awful lot of work ahead of us, and I'm going to dive into some of the aspects. Again, you'll hear some similarities to University Heights with what is in the Des Moines Ordinance. The ordinance does provide pretty clear definitions for what biased policing is, and then prohibits that. It also has clear definitions for racial profiling, and again prohibits that as well within the ordinance. Understanding that the equitable treatment that is required actually protects all classes. The definition for individual demographics is all-encompassing, so it is not just racial disparities that we're concerned about, but all protected classes. Several other actions that are prohibited in the Des Moines Ordinance include the discriminatory pretextual stops that was mentioned earlier, We actually call out prohibition of derogatory language used within the department, and we have that also for the entire city. We want to make sure that not only our public interactions, but our staff interactions are appropriate, that reports are written appropriately and do not have anything disparaging in the language that's used. Public input must be vetted when received from public agencies, public enforcement agencies, to make sure that any complaints are not racist in their bias, in their origination. And so this is to protect us from the potential of the public calling in with a complaint that really has a racial tint to it and not a law enforcement necessity. And so we want to make sure that we're checking on those types of complaints and not just assuming that there's validity behind them. There are police policies and procedures that need to be made available to the public on our website. Obviously, those are already public documents and have been available for some time by request, but we're going to actually put those out there in a public format on our website as well. The ordinance also calls for procedures in handling complaints. We do have a Des Moines Civil and Human Rights Commission, and so complaints can either come in through them to help give the complainant more comfort in that first conversation about a complaint, and can do the intake, if you will, and understand the elements of the complaint, to then pass that on to either the state Civil Rights Commission or over to the police department to go through our usual what we call OPS process, Office of Professional Standards. And that allows for an investigation to take place and outcomes on any complaints to work through the office. Additionally, the ordinance calls for the creation of a committee. This committee is charged with all policing and code enforcement policy review and seeking out opportunities for additional data collection and reporting out in a transparent way to the public. It's obviously very crucial that not only do we collect the data, but we find ways to report that out to the public and make that readily available and transparent. Our ordinance also includes a requirement for officers to intercede when they see any of the prohibited actions taking place. There is a call out for additional training, making sure that our officers are being trained on a regular basis with biased training, unbiased training, as well as de-escalation. Our entire employee base here in Des Moines will also get similar training on an every other year rotation. We have over 2,000 employees, so that's quite an undertaking as well. Our boards and commissions will also receive training on equity and where that can be helpful to them as well on our boards and commissions. So I kind of went through that quickly. There's also an annual review of how the committee is performing that needs to happen with the city manager, and any recommendations that come out of that committee for potential change to ordinance or city policies. So I think I'll leave it at that and be available for questions at the end. Thank you again for having me.
Outstanding. Thank you, Scott, for that overview of the conversation that occurred in Des Moines and where things landed. Looking forward to diving in deeper here when we have an opportunity for questions. Next up, we have perspective from Cedar Rapids. I'll start out by apologizing for my mistake. I thought we had the mayor on with us as well today. Unfortunately, he's not able to be here, so my apologies for that. That was my own misunderstanding. But the perspective from Cedar Rapids will be left in the very capable hands of the police chief. So with that, I will recognize you, Chief.
Thank you, Lieutenant Governor, and thank you to the focus group or task force for having me. I've been the police chief here in Cedar Rapids for about 7.5 years. I did my first 33 years in law enforcement in a police department that bordered Washington, D.C. Montgomery County is a very progressive police department of 1,200 sworn officers and about 600 non-sworn, and again, it borders Washington, D.C. I retired from there in 2012 as an assistant chief and came here being selected as the chief of police in October of 2012. Since I've arrived here, I've taken on, I guess, my progressive nature that I had in Montgomery County, and I brought it out here. But with respect to today's call, I'll focus on the reform efforts and everything that Cedar Rapids is doing and has been doing, not just since the murder of George Floyd, but since my arrival here. I've worked closely, or I've worked in the past with Ms. Andrews prior to today. So I'm familiar with her and a couple other members that are on this committee. I also serve as the legislative liaison for the Iowa Police Chiefs Association. So I'm familiar with Chief Logan, Chief Burdess, and their efforts that they went down to Johnson County and Iowa City, University Heights last month. Since the murder of George Floyd, the Cedar Rapids Police Department, along with the Cedar Rapids City Council, has been aggressive and progressive in implementing reform changes here within the city. We've worked with the Black Lives Matter group, or the Advocates for Social Justice. They presented us with the list of 7 demands, which on June 19th, the City Council passed a resolution unanimously agreeing to address these demands. And the demands are establishing a civilian or a citizen review board, increase the diversity and equity training within the city, address and strengthen the use of force directive of the police department, decriminalize marijuana and other lesser offenses, increase the policy regarding the body-worn camera program, participate in negotiations between the police bargaining unit here in Cedar Rapids and the elected officials, and also to address the qualified immunity issue. We are moving forward in a lot of these demands. With the first demand, a civilian review board, there is a city effort that has a strict timeline to utilize input from the entire city. All the community members are going to be requested to provide input so that the city and our department can implement a review board that fits this community, fits this city. If you go back to the 21st Century Task Force on Policing, the recommendation from the task force is to have a oversight board that fits the wants of the community. So I think that's the main focus of this effort to establish a civilian oversight or civilian review board that fits what this city and what this community wants. I'm in total agreement with the oversight committee to enhance the level of transparency and increase that trust between our police department and our community. If there are currently a number of requirements and confidentiality obstacles, to put it bluntly, that prohibits the exchange of certain information or review by anyone of our files. But I said it before, and I'll continue to say it, that our police department, I would open up for inspection our entire professional standards division files and our internal complaints and investigations. And what you will find is that this department is not full of officers who engage in a pattern of misconduct. And that, are we perfect? No, but I would offer and submit that we hold our officers accountable when misconduct occurs, and the records would reflect that. In terms of diversity, I know the city manager's office is exploring hiring a full-time diversity and equity person to help oversee the recruiting and enhancing the number of minority applicants, not just within the police department, but for as the city as a whole. I know the police department did not and still does not reflect our community in terms of demographics, and that still remains my highest administrative priority, is to increase the applicant pool for our department. But we are not near where we need to be and want to be, and it still remains a very high priority, my number one administrative priority. With respect to the use of force policy, immediately after the murder, we established a review of our current use of force policy, and we immediately implemented a duty to intervene section. And we also, the use of chokeholds was already banned prior to the May 25th murder, but we included at the request of the advocates for social justice specific verbiage to prohibit a knee to the neck maneuver, and anytime a chokehold or use of force, anytime a use of force was going to be administered, the knee to a neck maneuver is prohibited unless it's a deadly force situation. And we also previously had the requirement to use de-escalation tactics whenever faced with a use of force situation. In regards to the marijuana decriminalization, I've had discussions with Supervisor Stacy Walker, that as the liaison for the Iowa Police Chiefs Association, I would not oppose if someone was to recommend a bill to change the level of offense from a serious misdemeanor, which possession of marijuana currently is, to a simple misdemeanor. And that would, I guess, reduce the requirement to transport offenders for full processing at the Linn County Jail. With the body-worn cameras, we currently have a total implementation of a body-worn camera program. And before we implemented the program, our policy was reviewed by the Department of Justice, the American Civil Liberties Union, and I also presented the draft before my Police Chiefs Advisory Committee. I have a committee of volunteers in the community that does have Dedrick Doolin, our president of the local NAACP. They reviewed our policy and provided input, and our policy is in effect and is a very strong policy. With respect to negotiations, we do have a union, an established bargaining unit, and the negotiations primarily are between the union board and our human resources department within the city. And the contract that is bargained is public, and currently no elected officials participate in the bargaining, but I know the city is not opposed to allowing anyone to attend the negotiations. Primarily the contract deals with wages and benefits and working conditions. That has virtually little, if anything, to do with discipline. And then the qualified immunity topic, I know that the advocates of social justice during one of our negotiation meetings brought it up, but we did not get into in-depth discussion about qualified immunity. I think there's a lot of issues that still need to be fully understood by everyone. I have reviewed the ordinance that Mr. Sanders and Chief Kelsey spoke about. With respect to the ordinance, we have a bias-based profiling directive that governs the conduct and performance of our officers here that strictly prohibits using race or any form of profiling during the performance of an officer's duties. We in Cedar Rapids have not had any discussion about an ordinance that would, again, make that sort of conduct unlawful. But I would like to say that we do have a department policy that does prohibit any form of profiling based on race or ethnicity. And then the last point I'd like to touch on is training and accreditation. Currently, many of our training subjects, topics, and the hours already exceeds the state requirements, and in particular, implicit bias training. We have been presenting implicit bias training to our entire police department to include sworn and non-sworn for more than 4 years now. In fact, I had Ms. Andrews and some other community leaders attend implicit bias seminar that was presented by the Institute of Impartial Policing about 2 years ago. And retired Chief Noble Ray was the presenter. He's the former police chief of Madison, Wisconsin. And he presented that training to community leaders and members of my command staff. We also teach heavily de-escalation tactics, not only in entry-level training. We operate our own regional police academy, but we have 4 quarterly training sessions for all of our sworn personnel, and de-escalation tactics is heavily trained. And I would like to say last May, the Cedar Rapids Police Department was awarded advanced accreditation from the Commission on Accreditation for Law Enforcement Agencies, or CALEA. And there's currently 18,000 police departments in the United States, and the Cedar Rapids Police Department is one of only 5% of police departments or law enforcement agencies in the country that have basic accreditation, but we went a step above that, and we're advanced in that accreditation. And basically what that does is there's 484 standards that the police department is required to meet or exceed. And the police department, Cedar Rapids Police Department, has done that, has proven that. And I'm very proud of being able to state that this police department obtained advanced accreditation, and that it's national best practices, and that we are committed to not only adhering or exceeding those best practices, but we're committed for constant process improvement. So thank you again for having me, and I'll stand by for any questions.
Outstanding. Well, thank you, Chief, for that update from Cedar Rapids. Really appreciate it. I think for our members of the committee, you can see, if you recall our conversation from last month, the last time we got together, many of the elements of that proposed statewide legislation have been adopted in local ordinances. And so we can learn from some of the discussion and debate around that, and maybe some of the issues that have come up. How have these communities dealt with some of those issues? And so at this time, we'll open it up to to questions from the committee for the panel, and I'll take the chairman's prerogative, I guess, and and ask the first question or two. One of the things that's on my mind is, with the the local ordinances that have banned discriminatory pretextual stops, or in Cedar Rapids place, the policies that ban that, does that cause any challenges for law enforcement in terms of where the lines get crossed? In other words, when does, say, a description of a specific suspect and acting on that turn into something more than that? How do you deal with some of those issues? What feedback have you gotten from officers on the front lines of these discussions and enforcement of these laws? And I'll start with Chief Kelsey.
Our ordinance specifically talks about that, and I can't remember how it's described, but the suspect-based description. So our discriminatory practices, if you were investigating a crime or looking for a vehicle or an individual associated with a crime that had just occurred or had occurred, and there is a physical description that, a description is discriminatory in its very nature, whether it's clothing, skin color, gender. Officers can base stops on that information that is reliably presented. So it should not come into play at all. It should not inhibit that at all. The only place that it inhibits is on your stops. You say, you know what, I'm stopping this person. It's 2 o'clock in the morning. I've watched 10 other cars drive by, but this car is operated by somebody with dark skin, so I'm going to stop it. That absolutely would not be allowable. On the other hand, if it was a robbery just occurred at your local gas and go, and here's the vehicle description, and it's operated by somebody of this gender, somebody of this skin color, somebody of this clothing, then absolutely you could use that information to stop. So it does not inhibit our police.
Scott Sanders or Chief German, anything to add there from your experience so far? I know we're maybe at different places in terms of implementation.
I concur totally with Chief Kelsey. Officers are trained to base their actions on the information that they have been provided. So if they are provided with a suspect description, that's going to generate how these officers will perform or act based on the description of a suspect or someone who is a complainant or another officer has provided that detailed description. Again, I fully agree that actions based solely on race or ethnicity should be outlawed. And again, our policy is very specific that officers cannot and will not take any enforcement action based on a person's race or ethnicity.
Lieutenant Governor, may I add a comment?
Sure, of course.
I think that any confusion, or that the majority of the confusion, isn't on the part of the officers in these various jurisdictions that are progressive. I think that the confusion comes because although, for instance, Johnson County, I think we have done a very good job. Cedar Rapids is now accredited and has had solid policies for years, as the chief points out. There hasn't been chokeholds allowed, but it's different in Johnson County versus Lynn County versus Wapello County versus Tennessee versus Minnesota, and that's where the confusion comes in. You have a very professionalized police force, yet you don't have consistency. In fact, you don't have consistency in the way that you file complaints against officers. The duty to intercede, I would like to think that all of the officers locally know that that is what is expected of them anyway, but signing off on that or incorporating it into a police reform piece of legislation, make it clear to the public that this is a law and this is a requirement, not that, well, this month the police say they aren't going to allow it, but what are they going to say next year, or what? So I think it's that lack of consistency that is confusing, not for the officers on any particular department, but to the public that we police.
And I'd add, Chief, in our code of conduct policy prior to May 25th, our code of conduct policy required officers to take action when they witness a crime. But we felt so strongly because of what happened in Minneapolis that we made it a specific section in our use of force policy for officers to intervene when they witness another officer using excessive force. So even though technically it would have been a violation of our code of conduct, we wanted to be very specific so our officers knew that this is something that an expectation that they had to meet.
As did we. And it was a policy issue before, and it could have cost them their job before. Now it's very clear that this is a legally binding agreement that they could face, if not yet criminal charges, they certainly could face court action in civil court because they have a duty to intervene on a memorandum of understanding now. Again, for an example, the demands that were presented by our local demonstrators here in Johnson County, if you read through that list of demands, law enforcement in Johnson County was already satisfying many of those demands, but the public doesn't know that yet. We have not done a good job of, one, garnering true trust, as was very, very evident, nor I think where personally I've fallen down, and this has made me realize it, and I thoroughly was personally redeeming to me to talk to Paris Stevens. We have work to be done, and we need to take the ideas that we have, whether it's Des Moines, Cedar Rapids, or Johnson County, and we need to share those good ideas with law enforcement throughout the state and frankly throughout the country, rather than everything being piecemeal in a puzzle that's being put together one.
So if I could, on the Des Moines side of that, language matters, right? So within our ordinance, we spend a lot of time on how the description should read for bias policing. And we came down to 2 words: motivating factor. And so the demographics of the individual cannot be a motivating factor for the law enforcement actions that are taking place. And so we spent a lot of time on that. So motivating factor was important. The other aspect I would say is that, so that's the individual situation with an officer and a person of the public. The other aspect is the data that we provide or that we need to have so that we can look at if there is any disparate impacts, both at an officer level and as a department. And I think that will be telling as well, because that can give us guidance as supervisors and as managers if if an individual officer or a group of officers or even a neighborhood is being treated somehow differently. And so I think the data is going to be important in this discussion moving forward as well.
Well, thank you, Scott, because that rolls right into what my next question was. And we heard in our last meeting from Nebraska, who's had a racial profiling statute in place since 2001. A key aspect of that is data collection. One of the things that we learned in that discussion is they've got that down to essentially a science where it does not take long to collect the data and to report out on that. One of the questions or concerns I've had is, with the data that, what data do you want collected and how burdensome is that on the officer who's out there? And so I'd be interested to hear from anyone who's thought on the panel who has thought of those issues and how you're dealing with it in University Heights, how you intend to deal with it with the Des Moines PD. I don't know to what extent Cedar Rapids collects this data, but how do you capture the data that you need in order to be able to analyze something like that without being too burdensome and forcing officers to be spending 15 minutes of paperwork every time they have any interaction with the public?
It's incorporated right into our records management system, or our CAD, or computer aided dispatch. And basically it's a radio button that the officer clicks on while doing or after completing a traffic stop, and it asks a very, very specific set of questions. Gender, residence, city resident, county residents, it breaks that information down, and the officer just goes through and clicks it. And if it's taken the officer more than a minute to accurately complete that information or collect that information, the officer needs to be retrained. It is a very, very simple process.
So I think you may be aware, Lieutenant Governor, that there's discussion out there about the need to put race back into the DOT's driver's license database. Is it Tracks, I believe is what that's called. That would be incredibly helpful to us because that avoids the then pushback that can sometimes occur with an officer guessing at a race of an individual. That would be a simple way to really help because as I understand it, every traffic stop includes the swiping of a driver's license. And if that data does not have to be on the driver's license itself, printed, but if it were self-identified through the process of receiving a driver's license, that would be incredibly powerful in having third-party data reflect any disparate reporting that may come up. So I would put that request out there. Let's get that done. Let's get it done soon. Thank you.
If it can be collected off the swipe of a driver's license, it also leads to better integrity of the data as opposed to an officer either intentionally, and I believe that it has been done at other agencies when I look at other data that's not necessarily key and inaccurate information. So it goes beyond collecting of the information. There needs to be not just analysts, but there needs to be an audit of the information. Is what the officer is, the information that he or she is collecting and inputting, is it truly reflective? Is it accurate information as opposed to I'm just keying in 1, 2, 3, 4, male, white, resident, and moving on. There needs to be accurate data collection, and there needs to be severe repercussions for an officer who intentionally falsifies or makes up data that they're inputting into this database.
Chief, anything from your perspective from Cedar Rapids on that?
Yeah, you know, COVID threw us a big curve. I was having a conversation with Chris Barnum either in late February or early or mid-March about having that exact study done here in Cedar Rapids, and then COVID hit. So, but I would be open to have traffic stop analysis done. Again, my professional standards division does monitor on a monthly basis the traffic stops and the criminal arrest data. And whenever there is a high number of arrests or traffic stops where an officer has made a disproportionate number of issued a disproportionate number of citations or stops of a minority individual, an inquiry is conducted to ascertain the reasons and whether or not it's a legitimate action. And to date, all actions have been legitimized, that there was a reason for the disparate numbers. So, but again, to enhance transparency, I would be entertaining, you know, an independent study. And I know Mr. Barnum and St. Ambrose does offer that, and I'd be welcome and open to have that study done here in Cedar Rapids.
As Chief Thurman pointed out, even if we do it internally, people are going to question it, which is why it is great to have that independent scrutiny. That comes at a cost, though. You know, I have a 5-man department currently. I came from an 86-man department. I have 5-man department. That data analysis costs $10,000 for a 2-year memorandum of understanding. That is cost prohibitive for many agencies. Fortunately, I have a progressive city council that's willing to do that. But we need that piece. And as long as we're presenting, or this panel discussion has the members that it does, I want to throw that out there, is that agencies, I think more agencies would partake of this if they had a means to pay for it.
Well, thank you for that suggestion. I think there's a lot of good stuff that's coming out here in this Q&A. If I'm recalling correctly, I was trying to check my memory here, but I think Nebraska does have the racial information embedded in their driver's license data, and so I might be misremembering that from
in some places.
In some places,
majority,
okay.
And maybe some of the smaller communities not so much, but working on it or something like that.
Okay. Outstanding. And of course, we've had Chris Barnum present to this group back in February, and I found his presentation really interesting. And it may make sense to have him come back, and we can talk. First of all, get an update on the data, because I know there was some that was in process at that time for some communities. But secondly, to sort of get an idea of what does it take to scale that type of research so that we can have that type of research and analysis in more communities throughout our state. Because I think it's probably more than just a question of cost. It also is other resources in terms of having folks who are able to conduct his analysis. And as I remember, it was pretty labor intensive. But anyway, I think members of this committee can expect that we'll continue those conversations around what would data collection look like, and, you know, specifically how would that be accomplished. Maybe we can hear from the DOT on what that might look like and how we might do that. Hear from Chris Barnum again, those types of things. Are there, I want to continue with this conversation maybe for another 10 minutes or so, and I'm wondering if there are other questions from committee members.
Hey, this is Darius from Ankeny. This is just a general question about the citizens review boards in your areas. Are they? And I know one chief mentioned about training. Is that one of the criteria for being a member of the board, that everybody goes through training? And would that training include looking at the policies of the department, and what does that look like?
Our policy, University Heights, does specify that the board and the officers, I mean, there is a training component. It is fairly generic. It does not say what that is. Again, my relationship with Kevin will help guide that with the NAACP, but also, where does the board itself feel like they need training, what their deficiencies are, both for them and for the department, for the officers. So yes, our ordinance does specifically address training, but it does not micromanage and dictate exactly what those. Berman, up in Lynn County and Cedar Rapids, we've had lots of implicit bias training. We've done that for years, and we do it on a recurring basis. Discussion with Kevin Sanders talked about some other areas that he feels like perhaps law enforcement locally should shift their training or get some additional training in awareness and sensitivity and some other cultural issues that perhaps we haven't focused on. So we have some flexibility, but it is required.
Other questions from committee members?
I see Commissioner Baines has a question, and then I can go after him.
Oh, sorry, go ahead, Commissioner.
A couple of questions. I think, the first question I have is, we talked about State versus Brown earlier, and at least the current state of both the federal Constitution and the Iowa Constitution seems to have a little bit of a different standard than the policies that we've talked about today. And I know they're designed to address different issues in part, but I heard from both chiefs, or from the city manager and from the chief, saying that they didn't see any distinction there. But I think there are some important legal distinctions between the two. And how do you train your officers as a result? Because you have a constitutional issue on the one hand, and you have a city ordinance on the other hand that provides for a more restrictive view of these issues than the constitutional provisions do. And then the second question I just had generally for University of Heights is, it appears that their citizen review board has an active role in making factual determinations about personnel matters. I don't see that in the Des Moines Ordinance necessarily, but how do you work around Iowa Code Chapter 22.7 on confidential records, and how do you work around the Peace Officer Bill of Rights in that scenario? Those are the two questions I have. Thank you.
As far as the personnel issues and the role of the Citizens Advisory Board in University Heights, they are not active participants in the actual internal affairs investigation, in the inquiry. If it's a formal internal affairs investigation, the formalities, the necessities that you just Officers' Bill of Rights, notifications, right to representation, all of those things do apply, and we do treat that all as confidential records. Where our board differs from Iowa City's is that I hope that the board feels like they are more engaged in the process. They get to be involved in actually the screening of the complaint and the direction of the investigation. Chief, here are the answers I want. Instead of, for example, my experience with the Iowa City Citizens Board, where the review board is the mailbox for the complaint, and by Iowa City's ordinance, they hand that off to the Iowa City Police Department for investigation, and it automatically generates by ordinance an internal affairs investigation, which then triggers all of the things that you're talking about. In my experience at Iowa City, not all of the complaints needed to generate an internal affairs investigation. Many of them could be addressed with the information that was already there to either say, yes, there's an issue, but we can deal with it without an IA, or no, there isn't an issue. If it did require an IA, if identified an issue that at a University Heights that requires an IA and requires that formal process so that we can appropriately discipline, sanction, terminate, retrain the officer, then we will do that, but not all of them. Not every complaint is it necessary to go through that entire formal process. Well, I want them to be involved in the screening of complaints and the direction of, here's what we see as issues, Chief. Will you please go address these? Then I can report back on findings, not on personnel issues. If that makes sense.
Could you maybe walk us through then how yours works? Because it sounds like a unique animal, at least based on my understanding. So, I mean, could you kind of walk through a little, how the bill becomes a law, or where did the complaint come? Where does it go? How, from where it goes from point to point?
And as I said, we have been fortunate, and I hope I never give them any business as far as receiving a complaint. But the complaint would come in, and whether it came to me or it came through them, they would notify me of the complaint. We have received, Kevin, I will pick on you. Kevin Sanders said, this occurred, and I believe that it was because of my skin color. The complaint that the officer was rude wouldn't generate internal affairs investigation in University Heights, where it would potentially in Iowa City. But if the complaint was the officer was rude because I'm a black man, then that's going to fall squarely within University Heights ordinances, and that will require action by the Citizens Advisory Board. So Kevin says in his complaint that I was stopped. The officer came up to me. He was rude to me. He used these racial epithets when he was talking to me. And then he went back, and when he came back up, he told me to get the heck out of town, and if he ever saw me again, he was taking me to jail. So there's not even an arrest here that he's complaining about, but he's saying that he was mistreated. He was treated unprofessionally because of the color of his skin. So I'd say, all right, let me go pull what I can on that. Well, you know what? There's no formal police report because there was no police action, but there's in-car camera and there's body cam footage, and it records the whole stop. And I go and I pull all the information that's available, which in this case is only that body cam in this hypothetical case. I sit down with the board and I say, here's what's available for you to look at right now. Roll tape. And we play the video, and I suppose 3 different scenarios. One, it very clearly shows that what Kevin is alleging happened. There might be a slightly different perspective, but it very clearly shows that the officer wasn't just being curt. The officer was demonstrating a racial bias. That's real easy. We initiate an internal affairs investigation. We being the University Heights Police Department and me. I address it with the officer. We sanction that officer, whatever we're going to do personnel-wise. I report back that it was handled to them, and that it was a founded complaint, that there were training issues, there were personnel issues, there were oversight issues that were identified, and I specifically can say we're dealing with the oversight and training issue with the other officers, but maybe I can say that he was terminated, maybe I can't. I mean, depending on what happens with the officer, I can't necessarily share that information. Flip it the other way around, and the Citizens Advisory Board and I sit down and we review it, and what Kevin said absolutely did not happen. It's all on camera there, and it absolutely did not happen. Citizens Advisory Board can, if they choose, say, you know what? You don't need to look at this any further. We're satisfied that this complaint is inaccurate, that it's wrong. Maybe it's malicious, maybe it isn't, maybe it's a different perspective, but we don't think you need to investigate this any further. We, as your oversight committee, don't believe we need to go any further. Then it could fall somewhere in the middle where, for whatever reason, the interaction isn't captured, or maybe the interaction is captured on video, but you know, the racial epithets aren't ever used, but the officer is clearly being more directive, more terse, more angry, whatever the case may be. So it's falling in that, Chief, we have questions. Why was this handled this way? And was it because he was a black man? In which case, then I would go initiate an internal affairs investigation, and with their guidance and our policy, address the issues that they found as problematic. Again, personnel issues are confidential, so you know I can tell them that the officer is no longer an employee of University Heights Police Department, but I'm not going to say, well, the officer was suspended for 1 day or 2 weeks or whatever the case may be. We'll go back and report that here are the way we addressed your issues. You know what, we're going to have more training. Supervisor, we don't have supervisors because we only have one officer. But I can address specific issues of their complaint. I just can't necessarily talk about personnel issues, some of the personnel issues, many of the personnel. That makes sense.
So how do you?
You froze.
While we figure out why he's all frozen up, I'll circle back to one of the questions that he asked at the outset, which was, what about the issue of differing standards from like the constitutional perspective and then having more restrictive standards via ordinance or via policy? Has that presented any challenges for your officers?
You want to take that one, Chief?
Chief Chairman, you want to do that one?
Well, we don't have an ordinance, and you know, I think the constitutional requirements, you know, regarding you know the stops, we have not seen. I have not seen any issues regarding officers not complying with either the state or the federal constitution. Again, our you know, bias-based profiling directive or policy is very clear that you know, you can't make a stop based on an individual's race or ethnicity, and all the training that I think is in accordance with both the constitutional requirement that permits stops based on behavior of an individual, not their appearance of race or ethnicity.
We cannot allow officers, by ordinance or policy, we cannot allow officers or appear to allow officers to do unconstitutional things. I mean, we can't allow that. If the Constitution says thou shalt not do this, we can't say except in University Heights. On the other hand, if the Constitution says thou shalt not do this, we can say, you know what, we wholeheartedly agree with that. We have a clear policy or ordinance that says not only are we holding you to that standard, and that's the standard that you're going to be held to in federal court, but we're holding you, here's our administrative policy, and here are our expectations of you as a police officer. And yeah, you might not land in federal court if you violate one of these policies, but you are subject to sanction. All right, you're back.
Sorry, Commissioner, as you, I just followed up on the question that you had initially asked on, you know, the varying standards, having a maybe a tighter standard by local ordinance or policy than what the constitutional bounds may be.
Yeah, because I guess the only question I have is, I understand Cedar Rapids, it makes more sense the policy wise in terms of it seems to mirror, you can't, stop someone based on their race, but the University Heights and the Des Moines Ordinance don't talk about that. They talk more about if it was even a factor. So you could have arguably an objective reason to stop a car. Let's say there's a cracked windshield. And those two policies or ordinances don't necessarily care whether objectively there was a cracked windshield or not. They're trying to get behind the subjective motivations of what the officer may or may not have been thinking. And I guess I'm interested in finding out if Des Moines or University of Heights have even thought about how are they going to try to peel back and look at the subjective motivations of these officers to make these personnel decisions.
And you're right, it is, I guess, nebulous. Again, I'll go back to that officer who was stopping a car in the middle of the night. And, okay, Matt, you've stopped this many cars. If there's a complaint that's received, or if it's discovered during some sort of a supervisory review, but it isn't black and white. If he's saying, well, I stopped it because there's a cracked windshield, or I stopped it because there's this equipment violation. Maybe that's a license plate light out. Well, when was the last time you stopped a license plate light out? Not to say that legally you can't do that, but, okay, you stop that, again, hypothetically, but you've stopped that. Maybe this is your only stop, and maybe you say, hey, that's why I stopped it, and maybe we chat about it. But if you stop 6 people with license plate lights out over the last year, and it happens that every one of them is a person of color in University Heights, maybe we need to have more of a discussion about what your true motivation is. Are you stopping them because it's black and I'm looking for a reason to stop it? And that goes back to Dr. Barnum's studies too. Dr. Barnum will tell you, when we were with Iowa City and we wanted smaller increments of data so that we could potentially address issues with officers early on before it was, oh, here's a year's worth of data. Dr. Barnum would say you need to be careful. The shorter time period that you look at, it becomes more statistically irrelevant because you want the longer time periods. You want that pattern of behavior. You're absolutely right, Commissioner, that one time might not be enough. It still might generate a complaint and it still might mean a conversation with the officer. But that doesn't mean that it's actionable. It would be actionable if the officer said, when I asked him about it, yeah, he had a cracked windshield, but the real reason I stopped him is because he was black. Well, you know what? That's going to be actionable. That violates our policy. So it is not.
If I can just jump in, Commissioner Bands, you said that you had a question about if it is a factor, and I know that Des Moines says motivating factor, but if it is a factor, race should not be a factor in any way, shape, or form. It should be about the thing. It should be about the cracked windshield. So if race is a factor, then that is problematic.
I agree. I'm more interested in how do you pull
and how that happens. Yeah, and we understand that it is individual, case by case. I don't want to answer the questions you have for them because I do have my own questions and I'm waiting, but but I just wanted to point that's a big thing.
So in Des Moines, we were purposely trying to be consistent with federal and state law. We actually call it out in our ordinance that discriminatory pretextual stops are already prohibited by both state and federal law. And so it is also by the city now through ordinance. So from our legal advice that we were receiving, the use of motivating factor was also in case law dealing with pretextual stops. So again, we got our legal advice that motivating factor is consistent language with state and federal laws.
And Commissioner, if you know this, if there was a silver bullet, if there was an easy piece of documentation that would solve this whole issue, whether it be at a local, state, federal level, none of us would be having this meeting today. I mean, in my particular case, we're just a tiny little department trying to do the best that we can, or tiny little community. I really think that grassroots effort is good. I'm glad to see the Iowa Police Chiefs Association forming the task force so that not only are we growing it at the grassroots, but hopefully we're starting it, well, at least at the state level, at a legislative level, not starting it, but continuing it, and we will come up with more consistent policies or ordinances or laws that make it more standardized. So University Heights doesn't deal with it and come up with an answer one way, in Des Moines maybe a slightly different answer, Chief German slightly a different answer. They need to be tailored to individual communities and populations, but they should be tailored to it. They shouldn't, not everybody should have to reinvent the wheel, right?
Okay, so it's 11:42, and I want to make sure that we get Betty's questions asked and also have time to take a brief break before and leave ourselves time to dive into the State versus Brown case, because we have some really great guest speakers on that. So Betty, why don't you go ahead and ask your questions? I just want folks to kind of have an idea of where we need to be stopping this conversation.
Sure. I am grateful that we are having this conversation, and to Chief Kelsey's point, it is so true that we are in the infancy of some of these ordinances and things that are happening. But I also, to the point of Chief German, the accreditation piece puts in place best practice standards. And I think that's what, in terms of looking at a statewide anti-racial profiling ban, that's the goal, so that there is a foundation in the state. And that actually was the goal of the NAACP as we begun approaching this. I do have just a couple of questions, actually probably three. I wanted to start with Des Moines City Manager Scott Sanders. I wanted to, first of all, talk about the breadth. So that unbiased policing ordinance not only deals with traffic stop, it deals also with pedestrian stops. I'd like you to speak about that. And then also, if you could talk about the fact, again, we talked about this being in its infancy, and we're not done yet in terms of where we're going with this. One of the other points of the committee that is listed there, which is not really a citizens review board in the sense that most people know it, but they are supposed to look in the future at what the future of such a committee would look like. And then also the data collection piece, the consultant that you are bringing in as well, because I think that those are additional factors that we need to address. And I hope that we'll have time for public comment, so that we can, maybe one of the NAACP attorneys, Russ Lovell or David Walker, could talk a little bit about the constitutional difference and the motivating factor, and even some of the concerns around, or the questions that Commissioner Bayens brought up about the distinction with the Constitution and the state. So I know that's a lot, but if you could take that on, Scott, first.
Yes, I can attempt that. So I'm going to actually read out of our ordinance on the first question about pedestrian stops. Betty is correct in that it's more than just vehicular. Racial profiling includes, but is not limited to, vehicle, pedestrian, and bicycle stops where race, color, ethnicity, religion, or national origin was a motivating factor for the stop or enforcement action. So yes, the Des Moines Ordinance does go broader than just vehicular stops. It's meant to really go into any enforcement action, and whether that be, again, on foot, in a vehicle, or even a bicycle. The committee that's been created, correct, is probably different, very different than some of the others we've heard about. Dealing first off with the data collection and reporting out, doing so with an RFP that we will put out here in about another month that hopefully that will help us hiring a consultant and putting reports together and asking the question of how best to collect data. I fully expect that there will need to be probably dual course options with, as I requested, the TRACS database statewide, possibly having data information, racial information in that database, but then also having officers potentially participate in identifying race so that we have some double check opportunities there as well. Part of the responsibilities of the committee as they work through with the consultant data collection and reporting is to also review other structures out there for citizen committee input. Obviously, we've talked already about some areas that are off limits by state code with personnel concerns, disciplinary concerns, but there's a whole lot of other reasons why there's value behind public input. And so we're asking this committee to look at other examples across the country that do have citizen input directly into our police department policies and see maybe what would work best for Des Moines. I'm anxious to see what comes out of those conversations as well, to make, if you will, to kind of make the committee and the input more permanent here in Des Moines. Did I miss another question there, Betty, that you had?
I think you got them. I think you got them. So and of course a big part of what we're addressing is pretextual stops. And I know that Scott mentioned earlier that that by state, but I think it's really important to note that by court decision, discriminatory pretextual stops were forbidden, and by codifying this puts it in the code. I think that's extremely important to do. The one last thing I wanted to just check in with Chief German. I know we worked together on the 12-step I guess a negotiation when we were dealing with this shooting of Jeremy Mitchell and by Officer his name Lucas Jones, and at that time, you know, there was a lot of concern in the community with the handling of that situation. One of the things that brought up was body cameras and training. Actually, a number of the I hate to say demands, but the issues that we were working on were very similar to what you're working on with the protesters right now. But I wanted to check in on where you are with body cameras, because we know that there was an issue with malfunctioning camera. That was what we were told, and which helped miss a lot of the evidence, and that's one of the things we think is really important when it comes to dealing with traffic stops and things of that nature. And so if you could address that. I'm looking at my notes because I thought I had another piece for you to address. And then I just want to say congratulations on the accreditation. We haven't really talked much since then, so.
Well, thank you, Betty. The incident still is going through litigation, so I need to be aware of that.
But Chief German, I just want to just check in.
And
I want to point out that this officer is no longer there, and we were talking about training and sometimes we talk about and you don't have to say it, I'm going to say it, some of the bad apples and the situations that happen. But in the end, it turned out that his participation in another area wasn't the best, which led him to be dismissed. So anyway.
Yeah. So we're talking the other 12 steps. That was the Iowa Justice Alliance. And as a result of those meetings, all of our policies are online. And we did not have a fully implemented body camera policy or program back then when we were meeting. And the incident that you're speaking about, it was not a body camera, it was in-car video. But now officers all are issued and use body-worn cameras. Our policy regarding the use of body cameras is online, our website, as is our disciplinary policy that contains the discipline for violation of these policies. So I think that's, again, you can explore both those policies, the body-worn camera policy and the disciplinary violations and sanctions that are attached are all included online and available for everyone to review, and you know, they can provide questions or comments to us. But again, we want to remain very open. Those policies, again, are consistently reviewed and updated as necessary. But our disciplinary policy is based on a matrix of violations, and our violations of policy that are sustained go before a disciplinary board that is comprised of our 4 captains. They sustain that. If the violation is sustained, they provide a recommendation of discipline based on the matrix, and it's presented to me, and I can either increase, decrease, or leave the discipline level what the recommendation is based on either aggravating or mitigating factors. And then as required by civil service law, if the discipline that is imposed involves any sort of loss of pay or time, the officer is entitled to an appeal before the Civil Service Commission, and then that appeal is heard by the commission. So did I answer your question, Betty?
I think that was just fine, Chief. I think the last part was just to point out that oftentimes, and we've seen this in various places, there was a situation in Iowa City that we had to address with the previous administration, where an officer is involved in an incident like this, and they actually have other areas where they're lacking. And so it really is an opportunity to kind of see. I think last meeting we talked about see where the smoke is. So sometimes that smoke in turn ends up being something else. So you really do want, sometimes this is also a good thing for the police or the law enforcement agencies as a first line of defense, so that in identifying officers that may be problematic. So we saw that here, but we also, as Kevin, I don't know if he's still on the phone, can attest to, we saw that in Iowa City as well, that an officer involved in an incident ended up not being fit for this type of work. So thank you.
Okay, we're up against a break here soon. I see Bruce wants to ask one last question. I want to make sure that we're wrapped up by 12 o'clock on the button.
Yeah, appreciate that. I'm sorry for coming in so late, but I'm really interested in the people who have done work so far. I think the composition of these citizen review boards are going to be very important. They are very important. Is there a model out there that people look at? How do they get appointed? Is it for a specific term? Anything at all you can talk about how they are comprised?
In University Heights, they serve at the discretion of the mayor, basically. There is no set term. There is a selection committee, and by our ordinance, 2 of the city councilors and are chosen by the mayor to sit on that committee. And the council, or the ordinance, also specifies that the president of the Iowa City NAACP or his or her representative are part of that selection committee. Members are then It's up to the committee whether they want to do in-person interviews, whether they want to review letters of interest. But the selection to the committee is by majority vote. Now, we were fortunate that when we went through our committee selection, there were no split votes at all. There was agreement from all 3 committee members, and I learned this after the fact because I wasn't part of this. There was agreement by all 3 committee members on each of the candidates. Not to say that the people we didn't pick weren't qualified or would not have done a good job. The selection committee felt that there were 3 local community members who, for a variety of reasons, would serve that role well. The NAACP offered up, by our ordinance, there is 1 member that is specified to be NAACP, and they offered that individual up, and the committee selected him, and I was asked as police chief to offer up the candidates, and I did. They were all retired officers from either the Iowa City or the Coralville Police Department, and I offered them up with a brief history of each of them, and in the end, the committee said, Chief, we are comfortable with any of those. Which of those would you feel would make the best representative? And I selected Ants, former Coralville detective who had moved on to a second career at University of Iowa Hospital.
So one of the things we'll make sure we do is distribute the ordinances that have been passed, which include those provisions, and have an opportunity to kind of compare and contrast where those are at. So with that, a sincere thank you to the panelists. Thank you for dedicating so much time to this and being part of this conversation. Definitely very helpful to hear from your perspective as you've been wrestling with many of these questions. For those of us who are committee members here, we've been at this for almost 2 hours straight. So why don't we take a quick break? We'll be back at 12:05. I've got 11:58 right now. So that gives us about a 7-minute break. Get up, stretch your legs, grab another drink or something like that. And we will be back with a summary and discussion around the State versus Brown case, which was Iowa Supreme Court opinion regarding pretextual stops. So we will see you at 12:05.
Thank you again for the opportunity, and I look forward to see what comes out of everybody's local ordinances or local.
Thank you.
Yes, thank you for having me. Are you excusing me, or can I hang around?
You're welcome. You're welcome to stay if you'd like, but you're excused if you need to go.
Well, very interesting. Thank you. I appreciate it. I'll be hanging around for a while.
Awesome. Thank you.
Thanks. I'm going to stick around as well for the pretextual conversation.
Thanks, Scott.
Yep.
Thanks, everybody. Okay, why don't we go ahead and get started as I see folks popping back on. So next up on our agenda today, we have a presentation on a major recent Iowa Supreme Court case known as State versus Brown, which addresses the issue of pretextual stops. And as we'll learn from our panelists here today, the case decided the issue of whether the Iowa Constitution prohibits pretextual stops. But if you read the decision and the dissents, I think there's also a lot of discussion around the policy considerations around this issue, and thought it might be a good launching pad to continue this conversation around the issues. So to get that started, we'll hear from 2 speakers. We'll hear from Teresa Wilson with the State Appellate Defender's Office, who actually argued this case before the Iowa Supreme Court. And we'll also hear from Alan Ostergren, who's the former Muscatine County attorney and who filed a brief in this case before the Iowa Supreme Court, an amicus brief, on behalf of the Iowa County Attorneys Association. So what I'm thinking here from a timeline perspective is maybe I'll recognize Teresa first to sort of lay out the case and some of the arguments that were presented, and then we'll go to Alan for kind of the perspective from the state in that case, and perhaps from the County Attorneys Association as well. And then we'll kind of open it up to questions. I want to make sure that folks recognize that we have asked for your time until 1 o'clock overall, members of the committee, and we did reserve some time at the end for public comment. So I want to make sure we have the opportunity to do that and be efficient in our discussion here. So with that, I will go ahead and recognize Teresa Wilson from the State Appellate Defender's Office.
Thank you. I did represent Scotties Brown in oral argument before the Iowa Supreme Court in 2018. I'd like to share some of my insights about that case today, and I will do my best to condense 166 pages of opinion into about 10 minutes. A pretextual stop occurs when an officer uses a minor traffic offense as a means of investigating his hunch regarding unrelated criminal activity that is not independently supported by either probable cause or reasonable suspicion. Scotties Brown, who is African American, had probably the best pretextual stop case in which, or the best case in which to argue a pretextual stop. She may have committed minor traffic violations, license plate lamp violation, red, yellow light violation, but those violations were actually subject to dispute on appeal. But in Ms. Brown's case, the officer admitted that he would not have stopped her for any of those infractions. Instead, he stopped her vehicle when he became, in his own words, curious after he ran the plates and it came back to somebody with a gang association. Even the state on appeal conceded the stop was pretextual. Under both the US and Iowa constitutions, an officer must have probable cause or at least reasonable suspicion of criminal activity to stop a moving vehicle. In 1996, the United States Supreme Court decided Wren versus United States and held that so long as the officer had an objective reason for the stop, such as a minor traffic violation, the officer's subjective motivations in making the stop were irrelevant. The court recognized the possibility that expansive traffic codes could create an unsettling show of authority by law enforcement, but said that any remedy was through the Equal Protection Clause and not the Fourth Amendment. The Iowa Supreme Court had not previously addressed pretextual stops under the Iowa Constitution in any sort of substantive fashion. So Ms. Brown's case was really the first opportunity to do so. Ms. Brown asked the Iowa Supreme Court to adopt a burden shifting procedure similar to those in use in Delaware and New Mexico. Under this procedure, the state would give the objective reason for the stop. The defendant would then have the burden to show the stop was pretextual. And the state then could rebut that by showing that even if there was no pretext, the officer would have still made the stop. There was a third case referred to in my brief, and it was from the Washington State Supreme Court. They didn't use the burden shifting test, but instead they considered whether what subjective motivations the officer may have had and also the objective reasonableness of the stop. Before I get into the decision, it's important to acknowledge two different approaches to state constitutional interpretation. One approach, which is currently the majority approach in our court, is to give deference to the US Supreme Court's interpretation of similar constitutional provisions. The other approach is to see federal precedent as persuasive authority, but to independently interpret state constitutional provisions. With this dichotomy in mind, it really wasn't any surprise that the majority decided to follow Wren. The majority cited past precedent in which it had discounted reliance on an objective's subjective state of mind for an arrest. The court believed Brown's burden shifting proposal was unworkable given the differing practices in different counties and given the multiple variables that might go into an officer's decision to stop someone. The court also noted that if an officer was willing to engage in racial profiling, the officer would also be likely to lie about it. The court essentially described the problem as too big, with too many contributing factors for the courts to resolve. The court was hopeful that technology such as body and dash cams would help to root out pretextual stops and racial profiling. The court also agreed with Wren that any remedy was through equal protection and not Iowa's search and seizure clause. I would like to go through the concerns that I have with the majority's decision, and many of these are addressed in the dissents by Chief Justice Cady and Justice Apple. I'll start with the equal protection clause. First, it can cost anywhere from $45,000 to $125,000 a year to take an equal protection case to trial. My clients are indigent. They can't afford to do it, and quite frankly, I don't think most of them would know where to even start such a case. Second, an equal protection violation is really difficult to prove. You have to establish racial animus. So in one breath, the court says, showing subjective motivation of the officers is too difficult for the courts to do, but yet in another breath, it says that defendants need to prove that sort of motivation in an equal protection claim. Third, an equal protection analysis would apply to stops based on protected classes such as race, but it wouldn't apply to any other sort of pretextual stop. If somebody didn't like what I said here today and I get stopped tomorrow because of it, I don't have an equal protection claim. Finally, a victory in a civil equal protection case does not provide any sort of remedy in a criminal case. The majority's comment that an officer who commits racial profiling is likely to lie about it misses the mark. This may be true in some cases, but it's not necessarily a matter of an officer purposefully lying or purposefully being discriminating against race. Pretextual stops are just as likely, if not more likely, the result of implicit biases that officers may not even recognize. The majority's contention that increasing prevalence of dash and body cams will help to root out pretextual stops has potential. But as of today, Iowa has no law requiring law enforcement to record their interactions with police. The majority did not discuss the impact of pretextual stops on minority communities, deferring instead to the public's interest in enforcement of traffic laws. Yet studies both nationally and here in Iowa, as this group knows, shows Blacks and other minorities are more likely to be stopped than whites, especially for minor traffic and non-moving violations, and are more likely to be searched after the stop. Studies also show that African Americans are asked for consent to search more than whites, which is not necessary if the officer has probable cause to search the car. But once searched, Blacks and other minorities are found with contraband either at the same rate as whites or at a lower rate. Pretextual stops have consequences. As Justice Apple noted, such practices obviously send a message to people of color that they are second-class citizens. This in turn poses a problem for law enforcement. Tyler and Fagan have published a number of articles showing that a person's view of the legitimacy of police interaction, as judged by policing through a process the person views as fair and just, enhances the person's cooperation with police. This is referred to as procedural justice. If people of color do not view the police as legitimate, it has repercussions for law enforcement's ability to obtain information and cooperation. What can this body take away from the Brown opinion? In essence, any statewide attempt to address the issue of pretextual stops is not going to come from the courts, at least not under the search and seizure clause. And as I've indicated, the equal protection clause is really inadequate for most people. But there are steps that can be taken, and you've talked about a lot of them here today. There is no statewide requirement to keep data on traffic stops and searches. Instead, we have a hodgepodge of studies from a number of communities. To understand the nature and the scope of the problem and to understand the impact any policy changes may have, we need better data on stops. Video recordings of a stop are helpful in assessing the credibility of both the officer and the driver. It can provide corroboration for a suspect or a driver who claims abuse or discrimination, and it can provide protection to officers from false claims. The dissenting opinions recognize that pretextual stops are not always the product of overt racism, but are often caused by implicit bias. Required training in implicit bias can assist law enforcement agencies in serving their communities in a more just and fair manner. Of course, the state could simply enact legislation to prohibit pretextual stops and/or racial profiling, as other states have done. But perhaps one of the simplest ways to reduce pretextual stops is to enact a law that prohibits traffic stops for minor violations, such as equipment violations that do not impact public safety. Government intervention can have an effect. In 1999, as I mentioned, Washington's Supreme Court placed restrictions on pretextual stops. In 2012, the court loosened those restrictions. Rushin and Edwards will be publishing a study in the Stanford Law Review later this year, in which they used a comprehensive data set of 8 million traffic stops conducted by the Washington State Patrol between 2008 and 2015. They found that the 2012 decision was associated with a statistically significant increase in traffic stops of non-white drivers compared to white drivers. And they also occurred more often during the day when race was more easy to ascertain. What this shows, though, is that if there is a will and action to curb pretextual stops, it can be done. Thank you for your time. I'll be happy to answer any questions.
Well, thank you, Teresa. I mean, it occurs to me what a privilege we have to be able to have two folks who presented arguments in one form or another to the Iowa Supreme Court on this specific case and have the opportunity to hear from you. So thank you for that. I think we'll go with the same process as we did with our last panel. I'll have Alan Ostergen provide some perspective, and then we'll open it up to questions for both of you. So Alan, with that, former Muscatine County Attorney Alan Ostergen, who filed an amicus brief in this case on behalf of the Iowa County Attorneys Association.
Well, thank you, Lieutenant Governor Gregg. It's a privilege to be invited to participate in this committee with its important work. So just so people can understand a little bit of the background on what an amicus brief is, you have the parties to a lawsuit in a criminal case, the state of Iowa, and then the criminal defendant. And then lawyers, we love to use Latin phrases like amicus curiae, friend of the court. It's possible to file a brief if you're a person or organization who thinks that you have something to offer the court, typically where you think a court case has a broader importance. And you file a brief not as a party, but as somebody who hopefully has something original and positive to offer to the court to help the court get the right result. So it's a very common thing in practice in front of the U.S. Supreme Court. It's less common in our state Supreme Court. And certainly when I was a county attorney, we made an effort as an organization to file briefs in cases where we thought there was some sort of broad importance. The brief that I filed in this case, I was really focused on the importance of having reliable data if it's going to drive a Supreme Court decision on what is a mixed question of law and policy. Assisting Ms. Wilson's client was an amicus brief filed by a coalition of organizations that was citing data about traffic stops. And I filed a brief in response because I felt that the data were not robust enough to really help the court reach the correct result. The straight up question of law that the court resolved essentially aligns Iowa's law with functionally every other state. States have nuances in what their state constitutions say. The state of Washington, I think, is a state constitutional law outlier in a bit because it has a very differently phrased state constitutional provision about privacy, whereas Iowa and most states have some sort of copy of the Fourth Amendment. So as a question of what a court will look at, is this traffic stop or other encounter supported by objectively verifiable probable cause or reasonable suspicion that the law is not going to peer inside the officer's subjective intentions in making the stop. And so that's the rule in federal court, and that's the rule in essentially every state, with a few minor variations of how it gets applied in a handful of states. In writing that brief, I was impressed and enjoying the chorus of those who think that we need better and more data on the subject of how law enforcement agencies interact with the public. I think the coalition that filed an amicus brief assisting Ms. Brown did the best they could with what data they had, but the reality is that the data were really not very good that they had to work with. The comparator, the denominator and the fraction that they were looking at was very high level census data. And if you're familiar with Professor Berman's work out of St. Ambrose University, which has been cited earlier by Chief Kelsey, you know, I think his scholarship shows why much of the data that was in the Ms. Brown's amicus briefs really doesn't get us where we need to be. That it's a lot more complicated than simply saying what are the census demographics of a particular city or county. It's really need to gather data on what is the demographics of the motoring public in a particular area that you're studying police behavior. So he has done, the last I knew when I wrote that brief, which would have been winter of 18, he had done a second study, and I heard that he's being solicited to do other studies in other municipalities, and I think that's a good thing. Those studies will take a lot of work and be very expensive because it's going to take putting people in the field to really gather robust data about what is the makeup of drivers in a particular area in order to figure out, broadly speaking, are the police disproportionately stopping one type of driver versus another. As somebody who's now a former law enforcement official, but you know, I spent 22 years in that world. I want to point out that, and you know, sometimes we lose sight of this, that you know, just because a particular investigative technique is constitutional doesn't mean it represents what we choose to do as a best practice in a law enforcement agency. And I think that's a good thing. Frankly, if the Brown case had turned out differently, you know, it was a 4-3 decision that upheld the constitutionality of the stop. If that turns out differently, I question whether we have the same impetus to have a group like this, the same impetus to have ordinances and proposed legislation, and I think we would take the perspective more likely that, well, that'll get sorted out in the criminal proceeding, and if the judge doesn't suppress the evidence, then everything was fine. And whether or not the evidence should be suppressed, and I don't want to turn this into a 30-minute discussion of the exclusionary rule in criminal litigation, but whether or not the evidence was suppressed doesn't really answer the question, is this how we want law enforcement operating? Is this the best use of resources? Is this maximize public safety? Does this improve traffic safety, et cetera? You know, obviously lawyers who practice constitutional law, we sometimes fall into the habit of, you know, everything is a constitutional case. And very often the best things happen outside of constitutional litigation, and they occur in legislative and executive decision makers deciding that they're going to focus on a problem, working with the community and other stakeholders. We do need more data about traffic stops. I want to point out a different Iowa Supreme Court case than State versus Brown, and frankly, in a nice way, call out the implications of some of the decision making. So a case called State versus Coleman from 2017, authored by Justice Apple. Now, Justice Apple writes the principal dissent in Scott versus Brown. I would call it the principal dissent. I mean, Chief Justice Cady dissented, but he only needed about 15 pages to dissent. Justice Apple used 111 for his dissent in Brown. I'm sure Teresa enjoyed reading every one of those pages to prepare for this. So Justice Apple, in a case called State versus Coleman from 2017, writes a decision for a different makeup of the court. And the Coleman facts are: the officer sees a vehicle registered owner of the motor vehicle is a female who is barred or suspended from driving, does not have a valid driver's license. And so the officer decides to pull the car over, comes up to the car and realizes that the car is being driven by a male. The officer asks the male for his license and finds out that the male is also not valid to drive and charges him with the driving offense. So the Supreme Court rules in Coleman that the traffic stop basically had to stop as soon as the officer gets up to the car and sees that the motorist is not the invalid female owner and is somebody else, and literally that the officer is required to turn on his heel and walk away. Well, it's all well and good to say that we need to collect great data about traffic stops, but then you have a Supreme Court decision that essentially says you can't collect any data about that traffic stop. And the point I make here, I mean, that's a narrow circumstance and may not happen all that often. But if we try to make policy through Supreme Court cases, the likelihood is we're going to make policy in ways that are inconsistent, that aren't really well thought out. The court's job is to resolve what the law is in a particular case, not to take into account unintended consequences. Now, I don't think Justice Apple is opposed to collecting data in traffic stops, but he wrote a Supreme Court decision that would in some ways frustrate the ability of law enforcement to do that. And I think it just highlights again that when we make these decisions through the process that we're doing right now, I think you're going to get a better result over the long run. That's sort of my summary of it, and be happy to join Teresa in answering any questions that people might have.
Outstanding. Well, thank you, Alan. Appreciate your perspective on that one. You know, one of my theories here has been that by diving into this case on pretextual stops and which looked at the issue under the Iowa Constitution, that it would help us sort out some of the policy issues. And I think a good example of that, I think anyway, comes from this question. So, you know, the issue of evidence and proving discriminatory intent, I think exists whether we're talking about it under the protection against unreasonable searches and seizures that we find in the Constitution, and the question that Teresa raised about, you know, how would a defendant prove such a case? How would, in the expense of going through an equal protection case? But some of those same evidentiary challenges exist if you're trying to prove that this was a discriminatory pretextual stop as opposed to another type of stop. So I guess I'm wondering how, under either circumstance, how would a defendant prove that there was discriminatory intent in a situation like this? Maybe I'll recognize Teresa first and then Alan's perspective as well.
Well, I think part of the issue the court had with the proof was the fact that in a criminal case, it's going to be done in a motion to suppress, and it could really extend the scope of the proceedings, the duration of the proceedings, because in order to handle it, you need to get outside information, often patterns of practice and statistics. And I think the majority did not feel comfortable having that sort of scope in the motion to suppress. Now, with equal protection, that's what you're going to be looking at. You're going to be looking at any individual statements the officer may have made. We've talked about it before. If the officer actually said, "I stopped you because you're black," you know, that's not going to happen very often, but it could. There's some proof. If you look at the officer's history of similar traffic stops and you find that there's this pattern of practice over a period of time where he's stopping a person of color for a particular violation, but really only people of color, that can be used. And there are also proxies for race that we can consider. In my argument, I never once said that the officer involved stopped Ms. Brown because she was black, because there was absolutely no evidence in the case that he knew that. But he stopped her because the registered owner of the vehicle she was driving had gang associations. Okay, gang association can be a proxy for race. So I think there are a number of ways to look at it. And quite frankly, courts deal with subjective motivations, subjective intents all the time. You just have to have the proper scope of information.
How about you, Alan? Any perspective on that one?
So yes, I mean, obviously, if the officer, starts his report, being a irredeemable racist, I observed this motor vehicle at this location, then this is an easy inquiry. Assuming that's not the case, I think the thing that makes this really hard is that we're imposing on this question and this idea of, well, come on, we know the cops don't really just pull cars over all the time. You're only just pulling this car over because of some nefarious reason. And the reality is, police pull cars over a lot. And I think proactive law enforcement like that is certainly thought by many in the law enforcement community to improve not just traffic safety, but public safety in general. So yeah, I mean, you sort of have this oh come on standard, like, oh, you didn't really mean to do that. Well, I think the reality is we do think that police are going to stop cars when they see traffic violations, even if they're minor. That those violations are there on the books, and unless until the legislature is going to repeal them, I don't know how you can expect a law enforcement official to have a code of Iowa with, some of the provisions are highlighted and we really mean these, and some are scratched out and we don't really mean them. And then we're going to decide after the fact if you are acting with improper motives, because we just don't think we just don't think most cops would have done that. That is a totally unworkable standard. And that's why our Supreme Court, the US Supreme Court, and essentially every other state high court to address the issue in that way has rejected that as a method of decision making. Now, totally separate from that is, how do law enforcement agencies, how are they led? How are they trained? What expectations does command staff set for what is proper patrol behavior? Those are things that just are not suited for adjudication in a motion to suppress in a criminal case. They're suitable for who you recruit, how you train those recruits, and the command environment that you establish in a department. And so I think that's how you address that.
I saw in the chat that Jeff Wright wanted to weigh in here on this one.
Thank you, Lieutenant Governor. I actually do have something that we've been working on through our office, and was kind of a piggyback on a comment that Teresa made while she was discussing the case itself. There is a way to handle at least some of these stops in a little bit different manner than has been handled in the past, and that's by using the same system that's already in place for traffic cameras. The proposal that we had would take a multitude of equipment violations, which are not necessarily related to specific safety issues, but instead are what would amount to typical fix-it tickets, where someone would be pulled over. And instead of, it would create a new class of offenses for those. And instead of pulling people over for those, the officers would take a photo with their dash cam and then send that in, and a fix-it ticket would issue to the person. So for example, if a license plate light was out, the officer could take a photo of the license, citation, or a fix-it ticket would issue to the registered owner of the vehicle. They would have so many days to cure the deficiency, or a citation would issue. The same thing for broken tail light. These would not be issues where it would be a safety concern. It wouldn't be an issue where there would be any necessarily, I'm not talking about speeding. We're not talking about anything that would relate to drunken driving. These would be specific issues related to equipment or other related issues, I do have a proposal that I'd be more than happy to send the committee members that I think would be a good way to look about doing this. Because part of the problem with eliminating an officer's ability to pull someone over for an equipment violation or a registration ticket or a registration update on their license plate is, you know, those are important things that need to be handled, and we shouldn't just allow, why would someone renew their registration if there's no enforcement mechanism for it? Well, this would provide an enforcement mechanism that wouldn't either put an officer's safety at risk, and it wouldn't necessarily give an officer an excuse for a pretextual stop with relation to those types of issues. And it would still have an enforcement mechanism which would allow people to cure the deficiency or to fix their car or to update their registration.
I guess to build on that conversation just a little bit, I mean, one of the things that concerns me somewhat is, you know, if we're changing the enforcement of some of these, we might call them minor violations, whether they're, you know, tail lights or a modest amount over the speed limit or registration violations or whatever, you know, is that really the law anymore if it can't be enforced? I don't know if these are rhetorical questions, or maybe I'd encourage some of our law enforcement members and prosecution members to weigh in here on some of this. And then also, you know, are there negative public safety aspects to not being able to address some of those seemingly minor issues? How did these issues end up before the courts? Well, it's not because of the taillight violation in and of itself. It's because something else was discovered as a result of that. Perhaps it was discovery that the person was driving while intoxicated, or that there's an outstanding warrant for their arrest or something like that, and which do have very clear public safety impacts. So I guess I just want to get perspective from, certainly our panelists are welcome to weigh in on that, but maybe also some of our other task force members. What are our thoughts on that?
Lieutenant Governor, this is Darius. That would be my concern, that when does the traffic stop? Does it conclude at that equipment violation where you can't go any further and you can't investigate a DUI or a OWI or a suspended license or barred license? I don't know how that would work.
So,
Commissioner Baines here as well. I apologize, Betty. I didn't mean to talk over you.
No, you're fine. You were actually in queue for me.
You know, the question we want to keep kind of poo-pooing, I guess, for lack of a better term, like small equipment violations, but you know, the Iowa State Patrol and we're primarily responsible for traffic safety. I mean, we have over 320 odd traffic fatality deaths a year, and you know, things like brake lights matter. Things like obstructed views with cracked windshields matter. You know, those things have an impact on public safety and traffic safety in particular. And I guess I'd be a little, if we don't believe those things have value, they should be taken off the books, because either they contribute to the public safety mission or they don't. I guess the other piece, just to kind of echo what Chief Potts said, is, you know, most OWI stops are pretextual in nature. It's very rare that you have an individual that you see with a bud can in their hand, or you know, you see them stumbling as they get into the car. It's usually, you know, some driving behaviors that are troubling, and those driving behaviors then lead to that drunk driving. And I guess that's my concern as well, is at some point in time, if I see, or if an officer at 2 a.m. sees someone kind of swerving in their lane and they don't have their headlights on, I think our expectation from the public is that we want that person stopped, and not to take a picture of his license plate and turn it in later and hope that he doesn't, you know, hit a carload of people 2 blocks down the road. Those are the sorts of practical considerations I think we need to think about as we go forward.
And Commissioner, I did consider that very specifically, that this would not include things like swerving across the center line and the types of things that could be used to view impaired driving. These are very specific code sections which relate to equipment violations or equipment issues with a car that are also common pretextual stops reasons. This is not, and there is an enforcement mechanism. It's not an immediate safety concern to the general public whether or not someone has their registration updated. And there are a multitude of other issues like that that aren't specific safety concerns, and that's something that we addressed through our proposal to make sure that we were addressing the things that didn't have to be pulled over immediately because of safety issues.
I'm looking forward to hearing or seeing Jeff's proposal, because I know the NAACP actually, in working even with the city of Des Moines, but I believe in our process with some of the legislation, we have proposed very similar efforts. So that, I mean, that would make sense. And I think if Scott is still on, he probably may even remember that conversation. I did want to address there was something, I think, in your questions, Lieutenant Governor, that you spoke of, you asked about kind of figuring out if a person if it's about race. And I know it is difficult. It is a case-by-case things, but often people of color are asked, do you live around here? It's kind of that race out of place. What's, and I'm not saying that other people aren't, but where you heading, where you coming from? Those kind of questions that kind of lead and get narrowed into that you're out of place in this neighborhood, or what is your intention in this moment? I think that those are some of the things, and even beyond the traffic stops, if there's a sense of a person not giving them the proper attitude and that kind of thing, a lot of those are kind of a quiet way of addressing race. I also wanted to bring up that it is, I mean, we also can't, with the, I'm going back to Jeff's proposal, with the traffic stops, I heard Commissioner Ban say that there are a lot of things there that are there for safety, and if they don't matter, maybe they need to be removed. And I think that's a fair point, but I also think we do need to look at that. I mean, there are things that we may assume affect public safety that may not actually affect public safety. And we have that assumption because it's the way it's always been. And so now is the time for us to kind of take another look at what really does affect safety, because you have to also deal with, I know as a member of the Black community, constantly hearing about the reasons that people were stopped and the traffic and the trauma that goes behind that. So in addition to, dealing with, the stop and the ramifications, not to mention that many of these stops are based on their crimes of, indigence. Basically, if you're poor and you can't afford to get your, pay the $1,000 to get your license plates updated, or you didn't know that your license plate lamp was out, which is pretty common, things like that affect people. So I think if we're going to, lift up that there are safety violations that should be addressed, we also need to question if those things are really valid safety violations. My last thing I'd like to do is ask Alan a question. Alan, you mentioned that had the Scotisse Brown case went another way, that there may not need to be a reason for this committee or committees like this. You also, and maybe I missed it, but it seemed that you alluded to that, when in speaking about what the courts decide, or that those may not necessarily be, that those may be the floor, and that communities could do more beyond that. And maybe I misunderstood you, and if I did, I apologize. But it is one of the points that the NAACP often makes, is that because the Constitution or states make a law, an ordinance, some type of legislative effort, it doesn't mean that we can't look at that and say, and let's step up and do best practices. Let's do something better and greater. So just wanted to check in with you in terms of if you could just help us by going down that road with what you were talking about when you said that had it gone the other way, there may not need to be a reason for this group.
Sure. Thanks, Betty. And it's nice to see you on here. And it's a reminder of how hard you work on a variety of things and are involved in so much. My point is not that we wouldn't need it. It's that I think that if that case turned out the other way, right, I think it saps a lot of the energy out of what's being discussed here, because then we would pigeonhole a lot of these issues and just simply say, well, we don't need a citizens review board, just file your motion to suppress. We don't need another change in the laws. The courts will address this. And so it's not that it wouldn't be needed, but I think it takes the energy out of a conversation like this committee is having, and other stakeholder groups are having, and other communities are responding to. So it's not an either or, but I think it emphasizes that the people at large and other branches of government have a role to play in this outside of the courts. And you're exactly right. And I want to emphasize my point that just because a court says a particular action by a law enforcement officer is constitutional, which fundamentally means that the evidence generated by that officer in the course of doing whatever it was that was challenged will be admitted in evidence. Just because of that doesn't mean that is best practices. It doesn't mean that should represent the epitome of what a law enforcement agency strives to do. Law enforcement agencies can choose to do or not do things that a court would allow them to do. And so it's important, the accreditation things that Chief German was talking about, very important. Some of the ordinances that have been discussed here, very important. And essentially, and I'll make this point knowing that two people involved in my legal education are on this chat, and I can see them here. If you're, I would say this, and I think every lawyer should learn this, and frankly, anybody who cares about the legal system should learn it. The absolute worst way to learn about how the world works would be reading appellate court decisions. Now, as lawyers, we're guided by what our state high court and the U.S. Supreme Court says in those decisions. But if your knowledge of how the world works is based on reading slip opinions from the Iowa Supreme Court and the U.S. Supreme Court, you're missing 99.99% of what law enforcement does on a regular basis. And frankly, as prosecutors and certainly as defense lawyers, we don't see the encounters between law enforcement and the public that do not result in a criminal charge, right? Those cases never hit our desk. Now, Betty brings an important point up. The perception of people when they have a traffic encounter, even if it does not result in a citation, matters. And when I was county attorney, I would preach to officers, treat people in the public that you encounter like they're going to be on your next jury panel, because they may well be. And you know what? A lot of people will get a ticket and it's done respectfully and the officer explains everything and it's nice to them. And those are great prosecution jurors because they were treated fairly by the process. I think it's important, and I know that, the police chiefs that are on here would echo this, that how you interact with the public professionally, even if you're writing somebody a ticket, it pays dividends in the future as to how your agency is perceived by the community that you're entrusted to protect. And you just don't get that when you read Supreme Court decisions.
Okay, we are at about 8 minutes to 1. I see Teresa would like to respond to one of the questions. So I'll give Teresa an opportunity and we will wrap up this discussion.
Thanks. I'm going to be really brief. I wanted to address the OWI questions. Jeff's proposal, or the similar that I talked about, it doesn't make reasonable suspicion disappear. If you have a car that's traveling at 2 o'clock in the morning after the bar is closed and the headlights are off and it's swerving, you have reasonable suspicion to stop that car. It's the cases where you don't have that set of facts, where it's just the license plate light violation. And I'll give you an example. We've had recent cases in our office where specialized law enforcement units were involved, usually drug task force, and they acknowledged they didn't have probable cause to stop somebody, so they told the patrol officers to stop the person for whatever reason they could stop them for. In these cases, it was traveling 3 miles an hour over the speed limit, and it was a license plate light violation, and that's how they got around the constitutional requirement of reasonable suspicion and probable cause.
Okay, well, thank you, Teresa, and thank you, Alan, for taking the time to prepare and present to us today. Really appreciate your perspectives on this. I think it helped us follow up on the conversation around local ordinances, et cetera. For those of you who are on the line, we do have time for public comment. We will get to that. Just give me just a few seconds here. So appreciate everybody being a part of this. For the full committee, we've asked you to hold until 1 o'clock. But we do want to, it's very important to us, and the way we've operated is to have public comment and have some space for that reserved. I wish we had time to dive even further into some of these issues, because I think we'd learn a lot from it. But we do need to manage everybody's schedules as well and be respectful of that. So what we'll do in terms of managing public comment here on Zoom is we will address, if you're interested in responding, make a note in the comments or use the hand raise function. Nate Risto from our team will be administering the public comment aspect of it, and he'll recognize folks in order. I know that we did earlier have a hand raise from the Windsor Heights Chief of Police, so we will start out with them. And before we dive into that though, I fully recognize committee members may have other commitments starting at 1 o'clock. And so if you need to step off, go ahead and step off. I'll stay on. What we'd ask for public commenters though is if you could keep your time to about 3 minutes or so we can make sure that we recognize everybody. And of course, some of the folks I see on here, we've had to give a full presentation at previous meetings as well. So with that, is it Chief McCluskey who will be our first? Okay, I'll go ahead and recognize Chief McCluskey.
Thank you, Lieutenant Governor. Just real quick, back on the data collection discussion, I wanted to echo the other chiefs, and that I think the best method for that is something that's on the driver's license, maybe hidden in the magnetic strip, where it doesn't rely on an officer on the side of the street either guessing or asking somebody. And I think it's also critical that this body keep in mind that while race is a big component of this, there's also other things in this that need to be considered when we're talking about making sure that everybody's treated equitably and equally. And that includes gender, that includes gender differences, that includes orientation differences, and those are things that you just don't see. And so to have an officer on the side of the road trying to determine whether somebody they're dealing with in some cases is male or female even in today's world is somewhat difficult. And so the way to do that and do it effectively and collect that data appropriately is by way of the driver's license. I know that Chief Kelsey had mentioned that in their RMS system, they had a very simple form to fill out that takes just a couple of minutes, but I would encourage you to go beyond, Johnson County, Lynn County, and I know in Polk County and Des Moines, we do not have that in our RMS system, and it's quite expensive to add that. But if you get outside the populous areas to those smaller counties and smaller jurisdictions, they don't have the ability to incorporate something like that. And so the burden of data collection and collecting that and putting it together in some reporting mechanism is going to be huge. So I just wanted to echo that in my opinion and from my discussion, the way to do that and do it appropriately is by way of DOT and through a driver's license. Thank you.
Okay, outstanding. Thank you, Chief McCluskey. Appreciate your perspective on that. Next up, I believe, is David Walker.
Thank you very much, Lieutenant Governor and members of the panel. I want to respond to just a couple of points. One, regarding the difficulty of proving motivating factor. I want to second Betty Andrews' comment that if race plays any part in a stop decision, it's not right. The race should play no part of a decision to stop unless it's part of a specific suspect provided description and not go further on that. Second, how do you prove it? It's surprising what people do say. And we've seen that in the news and many other accounts. But the most important point, I think everybody has agreed, is collecting data. Professor Barnum's data, studies that have been done in Illinois and Missouri, all show that African Americans and people of color are stopped way disproportionately to white persons. Alan, hello Alan, it's nice to see you again. Alan commented that police pull cars over a lot. But Teresa Wilson's point, there has to be reasonable, articulable suspicion to believe that something, a violation of the law has occurred. There has to be probable cause. The Scotese-Brown case was 4-3, very closely decided, and it was decided following arguments when Justice Hecht was on the court. Justice Hecht was on record as saying automobiles should not be an exception to the Fourth Amendment. And it's probable cause. Said this is a close area of the law. The comment was made too that contraband is found, a bottle, a gun, something else. The studies show in different states and jurisdictions, and this comment was made too, contraband is found significantly more frequently as a percentage with white people than African Americans and other people of color. Finally, I'd like to say, and this is to Alan Ostergen's point about what should be our practices, regardless of what Wren versus the United States may hold, or various states, Massachusetts, Washington, others regarding pretextual stops. There is a huge cost in terms of community policing to pretextual stops. I have talked with a number of mothers, including state NAACP President Betty Andrews, but many others as well, who are terrified of police stops, who warn their children about them, and the data show that those are risk-filled situations. The public broadcasting system, together with National Public Radio and Marist, did a poll that was published just last month, June 5th, that 2/3 of Black Americans do not trust the police to treat them equally. And nearly half of Black Americans, nearly half it reported, have very little or no confidence that police officers in their community treat people with different skin colors the same. This is a real cost, not just to the Black community and people of color, but to police themselves and to our social fabric. So this is an area requiring attention. My last point is going to be regarding Alan's comment about the Coleman decision. Our proposal would require that there be a track stop data for every stop, whether or not a citation is given, whether or not a warning is given, so that we can chart whether and to what extent there are those disparities. Thank you very much for your time. I appreciate what this commission and each one of you are doing.
Thank you, David Walker. Appreciate your perspective. Next up on the public comment is Russ Lovell.
Thank you, Lieutenant Governor and members of the commission. I'd like to follow up just a little bit with what David said. I encourage the committee to watch the Monterey Little Jared Clinton stop, which was this Des Moines Police Department stop with their own body cameras. It's an excellent video for 13 minutes. And you get a sense of the degrading, humiliating aspects of these stops for people of color. You also might Google a article called Chokehold, or the book by Paul Butler, who's now a law professor at Georgetown, but who was a U.S. attorney for many years. And he tries to explain to those of us who are white what it is like to be a black person, knowing that you can be stopped at any moment for no reason whatsoever, and how that can go bad in an instant. And his analogy is, we can understand it much better today because we've seen what happened to George Floyd. I mean, his analogy is that if you're a black person, particularly a black man, it's like when you leave your home at any time, it's like you've got a chokehold right around your neck, which may not be, which can be ratcheted up at an instant when one of these stops occurs. If you watch the video of the Monterey Little stop, you see how provocative that officer was. And if those young men had not been given the talk by their mother and hadn't been so deferential, that stop could have ended in tragedy as well. So we can't lose track. David's point that, yes, sure, every time if you can stop anybody without probable cause or reasonable suspicion, you're going to stumble onto some things that are maybe criminal. But the other cost to law enforcement is how you just destroy the trust of that community, who then are not going to cooperate with you on other issues and who have no respect for law enforcement. I mean, there is a terrible cost when the stop is based upon a lie. When it's based upon a lie, that's the underlying reason. So I encourage you to think about that very carefully. With regard to the pretextual stops and Alan was right. He did a good job in saying, I mean, the Constitution sets the minimum floor. It is the minimum floor. It doesn't mean what's going on is good. It just means it's not so bad that it's unconstitutional. A municipality or a state can do better. They can provide a more middle ground, if you will, or they could in fact even bar pretextual stops completely. That you'd say you have to have reasonable suspicion or probable cause to engage in that. So you have that discretion. That's why we're here to do something much better than that. With regard to the discriminatory pretextual stops, yes, both the Wren decision from the US Supreme Court and the Iowa Supreme Court decision in Brown, both, of course, acknowledge that racially discriminatory pretextual stops are unconstitutional. But that has been largely ignored by officers who just brush that aside. We talked about how difficult it is to prove racial motivation, and you had a good discussion. I thought the chief from University Heights had a good example of how you might prove it. It is difficult, but just to have a prohibition in the legislation would go a long ways to ameliorating or minimizing that practice. The analogy I use is that when Brown versus Board of Education was decided in 1954, nothing really happened in terms of school desegregation for almost 10 full years until finally Congress embraced the Brown decision in the Civil Rights Act of 1964 and Lyndon Johnson signed it. Then it made a difference. The same is true here. We're convinced that having that bar on discriminatory pretextual stops in Des Moines enacted and embraced by their local governmental entity will make a real difference in terms of officers, how they respond. And particularly when you couple that with data collection. I often use Nebraska as my home state, so I was interested in Don Arp's presentation last week. And I'd often touted Nebraska as a neighboring state that barred racial profiling back in 2001, and they began data collection. Now in 2003, when the ACLU did their studies with regard to marijuana possession arrests, using FBI statistics, and that's an area where the police have vast discretion as to who they're going to stop and whether they're going to prosecute them. Nebraska was the worst state in the nation. More than, if you were African American, you were more than 8 times more likely to be stopped and arrested for marijuana possession than if you were white. When they did that study 10 years later, Nebraska had cut that rate in half by more than 50%. They were down now about the medium, around, instead of more than 80, it was down around 4. And so data collection has a real impact. When the bad apples know that they might be found out, they're going to be much more cautious. And others who might say, well, I've heard about implicit bias, and I need to be cautious and careful about that as well. Data collection is a huge part of what's necessary here. And I like Jeff Wright's comments in terms of the equipment stops. Please look at, we gave you a few months ago, our initial draft ordinances in Des Moines about how we recommended minor traffic stops be handled exactly how Mr. Wright suggested. And we think that that would also go a long ways to minimizing, again, the racial pretextual stops. Thank you very much.
Thank you, Russ. Well, we don't have anybody else in the queue for public comments, so that'll wrap up our meeting. I just want to say thanks again to everybody who participated in the panel and for our committee members who have dedicated a significant amount of time to this, and know that we've got more ahead of us. Appreciate you prioritizing this, and want you to know that we appreciate you. Bruce, are you raising your hand? Unmute him.
No, I'm just clapping. I'm just
applauding
people that spoke today.
Sorry about that.
That's okay.
The pitfalls of Zoom, right?
I'm trying to be hip. I'm trying to be hip.
Obviously, I'm the one who's not hip enough to understand that. But bottom line is, I just want to say thank you to everybody for prioritizing this in their time, for the thoughtful conversation that we've had here today. Obviously, we are wrestling with really difficult issues, and there's going to be a range of opinions on these things. But I appreciate that we've got a forum where we can have those conversations very openly and respectfully, and so thank you for that. In terms of our next meeting, you can expect that we'll have another meeting in August. We'll be working on a specific date, time, and place. Hope to be able to have these conversations in person, but frankly, they are working pretty well via Zoom, and I think it gives some additional accessibility. So we'll see where that all lands. Again, we've been going through this process of having had the broad overview of the state level legislation, which has been proposed in the past, and diving into specifics. Today, we obviously dove real deep into the issue of discriminatory pretextual stops and some of the law surrounding that. I could see us, while the agenda has not been set for the next meeting, I think it does make sense to maybe do some more exploration on the data collection side of things. That's something that we heard pretty consistently kind of from all sides here, and think about how we might incorporate some of those changes and what analysis of that data might look like. So I could see us going down that path as well. And in any event, look forward to that next conversation, and again, appreciate everybody's time. Have a great day, and thank you, everyone.
Thank you. Bye-bye.